We
Okay,
are
perfect.
recording.
All right. For the record, it's February 27, 2026, 9 o'clock a.m. I'm Phil Albrecht's hearing examiner for the city of Mercer Island, holding a hearing this morning on an appeal of some city permits from Lynn versus city of Mercer Island. We have an appellant in this case, an applicant, and the city as parties. Um, the hearing format today is going to follow the city's rules of procedure, which are kind of a little different for when it comes to appeal hearings in that they allow the general public to testify for some reason. So, but the general format is we'll have the appellant start off since they have the burden, then the city, then the applicant, then the general public, if we have any members of the public here to testify. Then for rebuttal, we'll have appellant go first, the city, then the applicant, and I guess the public for some reason is how that hearing examiner rule goes. And finally, the closing statements will be applicant first, then the city, and then the appellant. So that's the overall process, and we'll take a stab at entering all the exhibits for this hearing at the beginning. Before we jump into that, are there any other preliminary matters we need to get into? And I should say let's do introductions real quick too, as well. As I said, I'm Phil Albert's hearing examiner for Mercer Island, and Ms. Kiefer, you're here for the city. Is that correct?
That's correct. Eileen Kiefer, Madrona Law Group. I serve as a contract assistant city attorney for Mercer Island.
Okay, fantastic. And Mr. Yip, you're here for the applicant, is that right?
I'm here for the appellant,
Oh, the
Lin Lang.
appellant,
This is
sorry.
John Yip.
Okay, and who do we here have for the applicant then?
Yeah, good morning. My name is Morgan Weiss. I'm attorney for Tammy Liu and Can Chu, who are the applicants in this matter. Also present but off screen in my office is Doug Scott, who's also an attorney at this office and represents the applicant.
Oh, great. Okay, it looks like we have all the necessary parties here. And before we jump into exhibits, are there any other preliminary matters we need to address at this point?
I would like to essentially raise an evidentiary issue and bring it to hearing examiner Ulbricht's attention, if I may. Uh, is that okay?
Oh, yeah, go ahead.
Okay, so uh, some of the documents, a lot of the documents that were presented by Ms. Lin and her counsel as part of this administrative procedure are irrelevant, and so we're objecting on the basis of relevance. And secondarily, I'm objecting on the basis that they were surreptitiously obtained under false pretenses. I expect there will be testimony under this or about this later, but literally a week ago, Ms. Lin had a water line inspector come to my client's property under the pretense that there was a water leak that needed to be investigated. But in fact, what occurred was they ran a pipe test to locate the water line. And this was literally on the 19th of February to locate it, mark paint on the ground, and then photographed my client's property all over. And again, this was done under the pretense that they were just investigating a water leak. In fact, they weren't investigating a water leak. They were just documenting the property, most likely for purposes of this hearing. And so Ms. Lin has submitted photographs and depictions on a map of where the water line lays based upon this pretextual or investigation and has submitted evidence in this hearing here. So we're objecting to it on the basis that it was obtained under false pretenses, not proper under normal discovery standards. I understand that this isn't in civil litigation in the sense that we're not in superior court, but nevertheless, it was the manner in which this information was obtained would completely be excluded under CR 26 and its progeny. And then it's also just irrelevant under the rules of evidence because it's really not germane to the issues that this administrative hearing is going to determine. So I want to put that on the record. I don't know if you want to hear rebuttal or if you're going to make
Yeah, I'll let
rulings
Mr.
on it.
Yip respond to that if he wants.
Okay, thank you.
Sure, yeah. Mr. Yip, do you have any response to that?
Oh, yeah, I have responses to that. Okay, so I'll address it point by point. First, with regards to whether the documents are relevant, we would posit that they are relevant. I mean, these are photographs of the area at issue. One of the questions here is the location, with regards to the location of the easement, which is established by court order. but this just confirm the photographs confirm that those utility lines do in fact exist there. And besides, the scope of relevance is very broad, even under the evidence rules. Just anything that makes a claim of defense more or less likely. And so, if the opposing counsel wishes to renew his relevance objection later, I guess he can do so. But at this point, it would not be appropriate to exclude all those exhibits as irrelevant. Secondarily, with regards to whether they're taken under false pretenses, we disagree with that characterization. These photographs were taken, as I understand them, from what we call the middle easement in our brief, and Ms. Lin has a legal right to be on the middle easement. She didn't trespass into any other parts of the Kui Liu property, and so these photographs are appropriately taken from a place where she's legally entitled to be. And if the opposing counsel disagrees with the concept of photographs, he's welcome to do questioning or to put on his own case. But at this point, it would not be appropriate to exclude the photographs either.
So I mean, is it your contention then that the excuse me, I'm on the downhill side of a bad cold here. Is it your position then that the wording of the easement in allowing maintenance and repair also includes just identifying where it's located for purposes of an appeal like this?
Well, part of the issue was also to identify the line, the location of the line, and that is germane to the maintenance of the easement. So yeah, I would say yes to that.
Okay, all right, okay. Um, yeah, it's a little bit of a tough issue to come up, rule off on the fly, but I think it is probably, I would say it's within the scope of the easement. It's of marginal relevance. I mean, the fact that the water line is there gives some evidence on the intent of the parties to relocate it. Obviously, they probably wouldn't want to relocate it if they knew the water line was there. So it is relevant to that issue. So I'm going to overrule the objections based on relevancy and I guess kind of the fruit of the poisonous tree argument there. Well, let's go to the appellant's exhibit list since we were talking about that. We'll address that one first. Pull it up on my screen here. All right. And so it looks like we have a total of, was it 15 or 16 exhibits there for the appellants? And Mr. Weiss, did you have any other objections over the exhibit list from the appellants?
No, not other than I've already stated. Thank you.
Okay, and the city have any objections over the appellants' exhibits?
No objections.
Okay, so we'll admit exhibits 1001 through 1016. Let's move on to the city's exhibit list. Sorry, clicking on so many windows here. Okay, and the city had an amended list from what I recall. Hold on a second, where did that go? Ah, here we go. Okay, and the city has a total of 46 exhibits. Wait, this is not the amended list. Sorry.
No, Mr. Examiner, the city has 48 exhibits.
Okay, yeah, let me pull that up. Any objections over the city's 48 exhibits?
No.
From anyone? Okay, those are admitted as well. And finally, moving on to the applicant's exhibit list. And I'll put that up here. All right, we've got exhibits 2001 through 2009. Any objections over those from anybody?
No.
No, those will be admitted as well. Okay, that makes it a lot easier. We can get all the exhibits resolved up front. Okay, well, I guess we can just jump right into the appellant's presentation unless there's anything else we need to address at this point. Okay, so Mr. Yip, it's up to you at this point.
Thank you, Mr. Hearing Examiner. This again is John Yip from First Avenue Law Group, the attorney for appellant Melina Lin. There are two issues in this case in the appeal. One is with regards to whether the applicant may install and maintain structures over utility easements, and the second issue is with regards to the front yard setback. And from the outset, we would just like to confirm that the primary issue to be discussed here is with regards to what is known as the middle easement in our brief. To recap, there are at least three utility easements at issue. There are easements along the northern and southern side of the applicant's property benefiting the appellant. These were formed by the 1979 declaration. And there's also a middle easement, which was formed by a 1978 short plat. And that short plat was amended twice, once in 1979 and once in 1983. The issue to clarify, the issue before the hearing examiner today is not whether the middle easement exists, nor whether it is still in its original location. In fact, those issues have already been hotly contested and fully litigated in court in the case resulting in the order entered by the King County Superior Court in 2021. That court ruled that it refers to that middle easement as a 12-foot easement for ingress, egress, and utilities, easement number one. And the court goes on to say, which remains in effect and as a matter of law was not modified or terminated by the party's private 2017 driveway relocation easement. So it's already established by the court as a matter of law and also as a matter of facts that the easement still exists and is in the same location as it was depicted in the last map at issue governing that middle easement, which is the 1983 map. And I'll also further confirm that after that order was entered, the parties stipulated that it is final, and it was never appealed, and all appeal deadlines would have already passed since this was entered in 2021. So with that background, the real issue before the hearing examiner today is actually the following: whether the applicant has either installed or plans to install any retaining walls or rockeries over an easement. The Mercer Island City Code 19.02.020H is very clear. It says easements shall remain unobstructed. And then part two of that says no structure shall be constructed on or over any easement for water, sewer, storm drainage, utilities, trail, or other public purposes, unless it is permitted within the language of the easement or is mutually agreed in writing between the grantee and grantor of the easement. And here, there is nothing authorizing these retaining walls and rockeries over the middle easement. There's nothing authorizing them, nor has Ms. Lin consented to them in any way. And while we are not required to prove actual interference, because the focus of the Mercer Island Ordinance is whether or not the structures are built on a place where we have easement rights, whether those rights are used or not, that's not really germane to the ordinance. But just as further evidence, there actually is in fact a water line in that easement area, which was again confirmed by a contractor, a water line contractor, just last week. So, and that contractor also noted in his declaration and his written testimony that the retaining wall would in fact make it more difficult to maintain, inspect, and repair these water lines in the future. So the point of that is not that again the point is not so much whether we have to show actual interference, because that's not required in the statute in the ordinance, I mean, but rather that this is a real issue, not merely theoretical or something that is or hypothetical. This is a real issue, and therefore it is very important to Ms. Lin. So the relief that Ms. Lin primarily requests is that you, Mr. Hearing Examiner, order that the retaining wall and rockery be removed from the middle easement. I will also briefly touch upon the other points in our briefing, but those points are already largely addressed. So to recap, the other issues that previously there were also well, actually, currently there are retaining walls in the northern easement as well. However, the approved site plan already shows that those easements, those retaining walls will be removed from the north easement, which is good. And we appreciate the city apparently working with the applicant to require that change. So what we're asking is that change also be applied to the middle easement, meaning that the retaining walls and rockeries also be removed from the middle easement. The other issue is with regards to the front yard setback. The applicant has built a gazebo and a greenhouse that is partially in the 20 foot front yard setback, and the approved plans show that those structures would be removed from the front yard setback. So for that one, but there's no mention of it in the decision itself. So there might be some confusion in that regard. So for that one, we just ask that the hearing examiner also includes just amend the decision to require that all such objects, especially the gazebo and the greenhouse, be removed from the front yard setback, um, and to also set forth terms for confirming that compliance. Ultimately, again, the main issue is whether or not there are structures being built on the middle easement. The answer to that is yes, and under the Mercer Island City Code, those structures need to be removed. And so we respectfully ask that they be removed. Thank you.
And are you presenting any witnesses, Mr. Yep, or is that it?
That's my opening statement. I will now call my witness, which is the client, Melina Lin.
Okay, and I'm sure the attorneys all realize this. All testimony is subject to cross-examination today, of course. And also, I didn't mention before, I don't know how long this hearing is going to go, but I tend to have breaks or set breaks every 90 minutes for about 15 minutes. And if we get to after two sessions, we'll take an hour lunch break. So anyway, Ms. Lynn, let me swear you in. Just raise your right hand. You swear affirm to tell the truth, nothing but the truth in this proceeding?
Yes.
Okay, great. All right, go ahead, Mr. Yep.
Before Ms. Lynn begins, I just want to let the parties know, and Mr. Olbricht, we have two witnesses that are going to testify, and I told them both to be present or dial into the hearing at about 10 o'clock. So I'm just giving you a heads up that that might occur, but
Okay.
because I didn't know when the timing was going to be. So
Yeah.
sorry to interrupt. I just want to give you
No problem.
notice
Yes.
of that.
So, thank you, sir. All right, Mr. Yep, go ahead.
All right. Thank you. Would you please state your name for the record?
Lena Ling.
Okay. Is it your and could you describe the easements the utility easements on the Koi Liu property?
Object to
So the
foundation. I think
Okay.
they need established foundation before she can testify to that.
Okay. To your understanding, do you have utility easements over the Koi Liu property?
yes, I know I have it. So the opponent lawyer mentioned about the last week. I hired a water detector company come to detect the water line. It was like I pretending I was doing the water leak, but actually located the water line. So first thing I want to clarify that regarding the location of the water line
Let me object.
location,
This
it
is
was not found
non-responsive
out.
to the question.
It was not found.
Yeah,
Yes, I know I
we'll
have.
get to that. We'll get to that point later. I'm just trying right now to just try to lay the background for the easements. So to your knowledge, you have utility easements on the Koi Liu property.
Yes, it was
Okay.
also confirmed by the locator back about 2 or 3 years ago, maybe 3, 4 years ago. So I presented in my evidence in my appeal submission. So that was the first time I know for sure I have a water line in my neighbor's property. So the last week was only the second time double checking, double verifying. That's all.
Yes, I understand. Again, we will get to that. But I'm just trying to lay the background right now. Okay. So at least how many easements do you know of on the utility easements do you know of on the Koi Liu property?
I think as you mentioned about, I have a three. One's on the top 5 feet setback, northern setback. Another one is on the southern setback. And then under the middle part was under old driveway. It was old driveway. That's why it was in the middle of the property.
Okay. So now I'm gonna go ahead and just go to the exhibits. So I'm gonna pull up the city's exhibit number 43, and especially page 338. And I'll do a share screen to put it on my screen.
Okay.
Okay. This is do you recognize this document?
Yeah, I saw this one yeah, in the past. Yes,
Okay. And do you is this the northern easement?
I think so. Yes.
Okay, and the middle easement, is this windy area land here?
Yes, there was an old driveway. Yes, location.
Okay. And there's a southern easement, right?
Correct.
Okay. And this middle easement, it was also the location of an old driveway.
Yes.
Okay, but there's also utilities there.
That's my understanding is combined. Yes, correct.
Okay. And in 2020, were you involved in a lawsuit regarding whether or not the utilities easement has been relocated?
Yes.
Okay. And I'm now going to pull up city exhibit number 44. Um, okay. Can you read lines 9 to 15? Just ending over here, this period into the record.
Sure. The City of Mercer Island subdivision recorded under recording number 7812180972 and as delineated on survey thereof, recorded under the recording number 7911309020 as revised under boundary line revision recording number 8309159010 includes a 12-foot easement for ingress, egress, and utilities easement number 1, which remains in effect, and as a matter of the law, was not modified or terminated by the parties' private 2017 driveway relocation easement. King County recording number 20170329001022.
Okay. And this is the court order that was signed by the Honorable Matthew Siegel, right?
That's by the judge, I believe, yes.
Yes. Okay. And just want to clarify. So here, this says this order resolves all remaining claims in this case. Is that right?
Correct. It says that per the briefing of the parties and the parties' agreement at oral argument, this order resolves all remaining claims in this case, and the final judgment shall be entered accordingly.
Okay. So now I'm going to bring up and just to complete this line of particular line of question. So this is a stipulated order of entry of final judgment. And is it your understanding this is the final document that was filed in this case?
I believe so.
Okay. And to your knowledge, that this order, exhibit number 44, it has never been appealed. It's not presently on appeal, correct?
No.
Okay. It's not on appeal. Okay. So now I
No,
just want
it's
to go.
not on appeal.
Okay. Now I want to go to city exhibit number 9. Okay. All right. So this is, yeah, let me zoom out so it's how to establish what this is. So do you recognize this document?
I saw this a few times. Yeah, it's a survey plan done by Site Survey. It's a company do the survey job.
Okay. And do you know who hired a site survey?
I believe it's the applicant.
Okay. And for that one, okay, so is it correct that there's a line here down the middle, like a patch of land that's delineated by dash lines?
I can see that dash lines really match the old easement document for the old driveway before it was relocated. That dash line representing that old location of the driveway.
Yeah. And it says here ingress, egress, and utilities easement, right?
Correct. Not
Okay.
only driveway, but also utility easement. Correct.
Yeah. Yeah. And I know this is covered in the briefing, but actually the utilities easement and the driveway easement, they're covered by separate documents. Is that your understanding?
That's okay. Yeah.
Objection,
Now I
meaning?
understand now. Now I understand now. Yeah.
Okay.
Because that's a legal documents. Yes.
Yeah. Okay.
Okay. Okay, so that's background. So this is by the and I also want to point out the date of this one. This is from okay, let me see here. Okay, what is the date of this document?
April 4th, 2023.
Okay, and April 4th. Okay, and this was after was it after the order regarding the 12-foot easement?
Yeah, the order was 2021.
Okay, right. So this is a site plan. Okay, now I'm going to pull up exhibit number 23, the city's exhibit number 23. And do you recognize this document?
I know this is approved plan
Okay.
during the discovery, during the case.
Okay. And okay. So this one does it show the line in the middle easement?
Oh, disappeared.
Okay. But it was shown in this in the prior the prepare.
Exactly. That was exactly I was appealing. I said, why the survey plan changed?
Okay. And okay, and here this particular one, can you just read general notes number sorry, let me put up number 3.
Number 3, okay. The information on this map represents the results of a survey made in May 2015 and March 2023 and can only be considered as indicating the general condition existing at that time.
Okay. And then now let's go to the more recent. So okay, and then again, just to reestablish the background. So this one, this map, city exhibit number 9. What was the day of this one again?
April 4th, 2023,
Okay, so now exhibit 23, and this one says reviewed.
September
What?
11, 2025.
Okay. So, and then now let's go back to general notes number 3. What does that say?
I think it's the same thing. The
Okay.
information on this map represents the same thing, the March 2023, that was the last time updated.
Okay.
Can
So,
only be. Mhm.
yeah. Okay. So as far as you know, have there been any further surveys done by site surveying of this property since March 2023 based on these notes?
Based on this note, seems that they did not do any survey. Only the last one was March 2023, the same date for the both version of the survey per the plan. But I don't know actually they did or not because that's applicant
Okay.
hired survey.
Okay, but this what I'll call like the final site the approved site plan. This one did not. It doesn't reference any surveys that are not already referenced in the previous one. Is that your understanding?
It should be the same survey.
Okay, but yet, however, this one just omits the middle easement.
Right, right. They just,
Okay.
I think, by the way, I did have a chance to talk to the survey company because the survey, they did the survey for my house too, my water
Objection,
dog.
non-responsive, doesn't answer the question.
She hasn't even completed her answer. You need to at least
Well, you
complete
haven't,
your answer
no,
so you
she
can
did.
strike.
You didn't ask a question.
She was still answering my question with regards to preparation of the survey. I think that's relevant. If you don't like it, then you have let her finish and you can move to strike.
Yeah, so I'm
Oh,
continuing.
Go
oh,
ahead.
sorry.
So the same survey company did my survey. I talked to them maybe a few weeks ago, and they say that, oh, we just changed it. Oh, maybe we didn't do right. So they told me that they're
So
gonna come
I'll
out
object to
and
hearsay.
redo it.
I'll object to hearsay and move to strike.
All
What the
right.
survey company told her is absolutely hearsay and inadmissible.
Okay. Well, it's the rules of evidence are relaxed for these kind of proceedings. However, there is also a constitutional right for cross-examination. So I guess I'll sustain the objection.
All right. So moving on. Okay. So this is the exhibit number 23, and I just want to orient the hearing examiner, page 183. So Ms. Lin, can you describe what this document, what this particular page is?
It's a survey, show the existing condition
Okay.
of the property.
Okay. And then this one, does this map show any encroachment onto the north easement?
It's hard to tell because it didn't show the 20-foot line, but I noticed that there's that gazebo building disappeared. It's not on this survey. So I pass by the driveway every day. I see the two buildings stand there the same as before, no change whatsoever since they built that two building without permit. But the survey should be capture the existing condition on site, especially this project was for the rectify the unpermitted two structures on the backyard. So that's very crucial information. That's the main part about this project. So I'm very surprised that survey does not show all the illegal building on the survey because that's main focus of the project. So that's why in my appeal information, in my comments, I've been mentioning this. I see why the building disappeared and over and over. And also the dash line for the old driveway disappeared, for the easement disappeared.
Hmm. Okay. So again, we're comparing. Yeah. So again, just to recap, we're comparing. Um, yeah. So this and this. So does this one doesn't also? But but from you what you see, there is a gazebo over here in the in this area.
Not only from what I see, we took a photo that's in the
Mhm.
exhibit. In the photo shows that's two buildings standing there square. No change whatsoever from when they built illegally without
Okay.
permit.
Okay. So let's just
There's
go back to
evidence. I
the.
don't know which exhibit, John.
Yeah.
That's
Sure.
you can point out. Mhm.
Yeah. So let's just go back to the Middle Eastman issue first. Okay, so I'm back, and just for everybody, I'm back to exhibit number 9, the city exhibit number 9. So on this one, is it your what is your understanding again of this I don't know line this area here in the middle?
In this area shows a driveway.
Okay, but is this
These
the
are
middle? Is this your middle utilities easement as far as you know?
correct. Middle
Oh,
easement,
okay.
driveway, and also the middle easement. We call middle easement in our brief.
Yeah, but the driveway, but yeah, but I'm not talking about the driveway. I'm just talking about the middle utilities easement. This is your understanding of the middle utilities easement, right?
Correct.
Okay.
Yes.
And based on this drawing, uh, is it your understanding that there are retaining walls or rockeries in that middle easement?
Yes. It's shown on the plane.
Okay.
Shown on the survey plans show that intruding into that dash line.
Okay. And these, then just to confirm, is these small, like, are these small square boxes? Are those what you understand to be the retaining walls?
I think from the photo, because I never go to that part of this backyard, my neighbor is very hostile whenever I ask her for the reasonable access. From the 3 years ago, they refused me from going, and this time the same thing. Even though we got a photo, they're still against in a court appearance by their attorney, right? So, but I can see from the driveway and from the photo that returning wall is very large, and they are there. And also there's a fence above the retaining wall, completely close that part of the yard. So for access, I don't know, the fence should be taken down or not. I
O-
don't, that's another thing, is enclosed. Um, the whole
Okay. Well,
reason is because my neighbors are very hostile for me to access for that easement 3 years ago, 4 years ago, when first time I needed to upgrade my size of the water meter. So that's why we discovered that's the location of the water pipe. It's
okay.
just
We'll
really,
get to the photographs. Right now, I'm just trying to establish the what this diagram shows. So as far as you know, these boxes are those representing retaining walls based on what you understand.
yes, it is.
Okay. And just based on your observations, again, we'll get to the photographs later. Just based on your visual observations, do you in fact see retaining walls in that area?
Yes.
Okay. Now, I just want to, again, also before going to the photographs, I just want to talk about the Exhibit 23, the approved site plan. And under this one, does are the retaining walls still shown?
Yes.
Okay, and as far as you can tell, and I'll move slowly, Exhibit 9, which is the one that from 2023, versus Exhibit 23, which is from 2025. Do you see any differences in terms of the shape or the size of the retaining walls as depicted on this map on these maps? Okay. All right. So moving on. With regards to the now let's talk about the locates work. Can you talk about the locate work from from last week? Like
Yeah, so
mhm.
give some background. I received a notice from the city of, I think city of Mercer Island, mentioning about my water line is leaking. It's because the city of Mercer Island changed a smart meter, water meter. It can detect every half an hour, every 15 minutes, there's a reading. My house meter is reading every single minute. So I got the notice, I think towards around December. That was before the holiday. I had a travel plan, so I was out of town. So I told the city of Mercer, I'm going to try my best, locate where's leak as soon as possible. So around in January, I was traveling. I was back in February, early February. So I had my niece, Rebecca. And I had her, I said, can you please hire a locator, locate where's the leak? She just hired a locator, but at that time, we spent about 10 days or two weeks trying to coordinate for the access. Tammy, the applicant, refused us from entering the location, refused the date, and say this date, that date doesn't work. None of the date works. Finally, she put it out the date far away. Then we have to scramble around, try to schedule with the locator. So finally, locator went in. But when the locator detect that time, they did not locate the line location. So they map all over the yard, everywhere, everywhere. Then finally, they say they find a leak location, which is in my courtyard, in my house, in the courtyard. So I hired, when I come back in February, I hired a contractor, open my courtyard, find out there's no leak. It's dry like a bone. So we called the locator, which is not leak. Then they say, well, we're not guaranteed the accuracy. We can come back again. So they suggest this time, in order to really locate where's the leak, we need to identify where's the location of the line first. That total makes sense because when they know where's the line located, then they can use that specific machine, the instrument gonna detect that location little by little. It's about a 300 feet long distance from the side of the North Mercer Way, the meter location, up to my house. So we start to do that. So again, I try to schedule that appointment with my neighbor, and it was so difficult. I was going to do that work way sooner, but then finally we booked appointment. It was last Thursday, I believe last Thursday. So that day, our job supposed to have two things. Number one is locate where's the line located because they want to do a good job now. The number two, then detect the leak. So that day, supposed to should show up at 8 a.m. By 7:30, I already got my helper, the plumber, open the line already. The technology, by the way, and maybe add a little bit background. The technology, how to detect the line location is we require to insert a fish tape. The fish tape is a metal line, not very big, about maybe a half inch, not even half inch, maybe a quarter inch wide, flat piece of the metal. Insert that fish tape inside the water line. My water line is about 1.5 inch or 1.25 inch. So pretty big size. Insert that line inside the tape as far as possible, ideally to cover the whole entire length of the water line. Then the whole instrument gonna detect that fish tape location, magnet or some that technology. I don't know how they do that, but they have a that instrument locate the line. Then they use a different instrument and locate the leak. So at 7:30 a.m. on that day, the technician supposed to show up at my job called me. He told me he's really sick. He said, I'm really sick. I'm going to the hospital now. I was like, what? What are we going to do? We got people, I already got a line open already, and I'm just waiting for him to show up. So we scrambling around. I called the office. I called the office. I said, what are you gonna do? I said, we tried so hard to lock today with my neighbor because my neighbor is very hard, do not allow me to enter. I respect her, but even though I have the right, but I still respect her schedule. So finally, the office told me, we're gonna send a different guy because you already insert the fish tape. Then why not we locate the line first? Then we're gonna send the leak detector later. The reason is only two technicians in this office can use that very expensive machine to detect a leak once line is located. That's office CNI office told me. So this technician is sick. Another technician was on maternity leave. Maternity, so none of them available. So instead, he sent this this technician over. He said, why not we detect the line for you first? At least you're gonna know the location. And I said, okay, why not do that? So I can get a ground cover up. So that's what happened. So that day, last Thursday, they sent a second technician and he come over very quickly. Within half an hour, he detect the line location. That's how he mark on the ground. And also he told me, please keep those mark on the ground because we're gonna send the technician once he recovered back again to detect the leak. So now I have a little bit other problem because the length of the detection can maximum about 240 feet. The fish tape's length is only 240 feet. Now the detected line, the signal end at about 220 feet. So the signal disappeared. So then they told me I have to open the pipe from the other end to do another line location or something. So I'm still tackling it. So that leak problem has not been fixed, and I'm under the pressure. I need to fix the leak. So it just
Okay.
happened. It just accidentally happened at the same time, leak detection and line location. And by the way, I don't have to locate the line again because the line was located about 3, 4, I don't remember the date, 3, 4 years ago in my exhibit of the comments to the city. I say I know the line located in my neighbor's yard. Not today, last week, they located the line still the same location, still the same around the same spot of the yard. So really
Okay.
does not change the facts, just double verify.
Okay. So the just to summarize, the line location, is it related to or in preparation for repairing the water leak?
Yes, it's solely for the water leak. It's just a byproduct because we have this hearing. So I say, hey, why not, since you do that, why not just do more for me? So technician, then they did a declaration for me. It's just all the facts. I already
Okay.
told my neighbor, I said, doesn't matter they do another line locator or not, it's already a fact. This time we just want to put more official documentation to present to the appeal board. That's all.
Yeah. Okay. Now I'll get to the declaration. Okay. So I'm gonna pull up Lynn Exhibit 1003, and this is specifically the page that is 1003.21. Do you recognize this particular page, of this document? Okay, and can you describe what this is?
So this is a indicator of the line location. It kind of like to translate the language from the locator, put some little flag and also paint on the ground, transfer into a map, just rough indicator of the location of the water line. And it just happened so accidentally. That's about the end of the neighbor's property, the driveway. That's a signal got lost. He could not locate it anymore. I wish he could do more because,
Okay.
yeah, exactly.
Okay.
That's locator did the line.
So that's the located line. And it's your understanding that this located line, that's the highlighted, right?
The
Is that
yellow, yes,
yes, okay. And is it your understanding that the located line generally fits the contours of the middle easement?
yeah,
Okay, and just again, just to refresh everyone's memory, exhibit number 43, city exhibit number 43. This squiggly and down the running down, roughly down the middle. This is the middle easement, to your understanding, right?
简单，嗯
Okay, and that's also what this squiggly shows. That's also the middle easement. The yeah, where this in this middle line. Is that what it
yeah.
is? Okay. All right. So now I'm going to go to So now I'm going to go to the photographs. Before I do that, so generally, is it your understanding that the contractors stay within the easement area?
Contractor went in with neighbor. I did not go in because neighbor refused me from enter that yard. Even though I think I have absolute right can go in, but I did not contest. I just let that go. So the contractor went in with Tammy. So Tammy should know where they went.
Okay. And then, so the photographs, those are taken by the contractor, not by you. Or were they taken by you?
Which one? This photo, this paragraph?
No, let me just go to the photograph, one of the photograph I'm talking about.
This is
Lin
taken by
Exhibit
the contractor.
1004. Who took this?
Contractor.
Okay. What does this photograph show?
They show there's a blue line on the ground, which is the location of my water line to my house, and also show the background of that yard. There's two building. You can see there's the gazebo and also the greenhouse, and also the backyard, some retaining wall, and also the water vault.
Okay, so the blue line is that your understanding that this is the water line?
Yes,
Okay, and it's also your understanding this water line would actually that this retaining wall is over this water line?
yes.
Okay, I'll go back to Lin 1003. No, it's upside down. Okay, there's some more photographs here. I think up top. Just want to go over some more, for further illustration. So, what is this is 1003.04. What does this show?
Water line. All blue dots and the little flag show the location of the water line they detected.
Okay, and this is a retaining wall, right?
Correct.
Is this one of the retaining walls that you are concerned about?
Maybe. Yeah.
Okay. Yeah, this one we already talked about. Here's another one. Can you just briefly describe this one too?
This one, there's a fence next to the shrub, and behind the fence is a current driveway. So this part is right behind the current driveway, and also there's a retaining wall there, and also the fence. And now you can see the little fence too on the left side is all closed. So they have to walk around to access to that point. Maybe they have a gate. I cannot tell because I never went inside there myself.
Okay. So generally, your understanding is that there are retaining walls over your middle easement.
Yes.
Okay, and a key purpose of this appeal is to seek the removal of the retaining wall sections over your middle easement, right?
Yes.
Okay. All right. So just a few more questions. So now I'll just briefly touch upon the the north easement. Let me pull this back up. All right. So this is city exhibit number 23. Okay. And I see that along the top part of this is like a dashed line, and it's like says 5 feet. Is it your understanding this is the north easement?
Correct.
Okay, and are these all retaining walls in the north easement?
For the plan,
Objection,
yes.
lack of foundation. She's testified
Correct.
she doesn't know or wasn't there.
All right, Mr. Yip, rephrase.
Okay, to your knowledge, are there any retaining walls in the north easement?
Objection, foundation.
Okay, based on this picture, are there
Yes.
Is this a survey map?
Yes. Based on the survey, there's an easement inside that 5 foot.
All right, and
Yes.
based on this survey, and this survey was prepared by applicant's surveyor. Am I understanding correctly?
Correct.
All right, and according to this survey, are there retaining walls being shown on the north easement?
Correct.
Okay, and now I'm going to go 2 pages down. This is what is this page showing?
Yeah. I just want to make sure, is
Yes,
this approved plan, exhibit
yes, this is the approved
23?
plan, exhibit number
Correct.
23. Yes.
This one does not show inside that 5 foot.
Okay,
No.
but what is this picture show? What is the purpose of this particular page?
Objection, foundation.
Based on what you know, what is the purpose of this page?
Yeah. Just so everybody know that my pre-career, I was a structural engineer, so I do the plan all the time myself. So that's why I read the blueprints, I do the design myself. Based on this is a very simple project, very simple, really nothing. It's just like a survey, you show the existing condition, and then you show another plan, which is they call site plan. I may not call site plan myself, but they call site plan. That's okay. Site plan is show the new condition or the call proposed structure on the plan. Proposed structure is supposed to be built. So from the side plan here, it shows the returning wall is off the 5 feet recess. And also same says, oh, yes, answer your question, John.
Okay, so just to summarize that, so I'm going to go because I just want to be very clear. So this is page 183, and according to this one, according to this page, they are this is the current one that supposedly shows current conditions, right?
Survey showed existing condition and
Okay.
shows that returning was inside the 5 foot, and the side plan showed it's out. So that
Okay.
means they're gonna have to remove it.
Okay, and is that satisfactory to you for them to remove the retaining wall from the north easement?
Yes.
Okay. Um, and um, and however, for the okay, let me go back 2 pages. All right, so here, this is the survey. Am I understanding correctly?
Um, I'm so sorry, John. Is this a survey?
Oh,
Is
okay.
that to show the survey plan? Then the survey.
Yeah. So let me just zoom out so everybody can see better.
I'm sorry, I just blinked my eye.
Yeah, no, this is exhibit 23, page 183. It says topographic
Yes.
survey.
Yes.
As far as you know, this is supposed to depict the existing condition, right?
Correct.
Okay, and again, even though the middle easement somehow not shown, these retaining walls towards the middle, those are the ones you're concerned about, right?
Yes.
Okay, now let's go to the site plan, which is the proposal. So, in this proposal, are those retaining walls that you're concerned about? Do they still appear in this site plan?
Correct. Still on the plan.
Okay, so what you seek in this action, in this appeal, is the removal of the retaining wall sections in the middle easement.
Correct.
Okay. All right, so that's it for the easement issue. Just want to briefly touch upon the front yard setback, and then I think we should be about done. Okay, so all right, so previously, okay, so is it your understanding that the gazebo and the greenhouse may be in the 20-foot setback?
This is absolutely sure within the setback because you can see there's 20-foot measurement. So one challenging about this is it's very hard to tell by eyeball because by you looking at the site, you cannot tell it's within or out. So the survey is extremely important. So from this plan, I can see this is I saw this is the XB the 9, so the old plan is not permitted plan. So I can see that the gazebo is within that. Everybody can see there's a dash line here to show the 20 feet. John, you can point about the 20 feet there. Go below a little bit.
Okay.
Below. You're
Okay,
talking
and
about the front
okay.
the setback, right? Is that the question?
Yeah, no, I mean,
Here.
yeah, just it's in the setback, but this is the
Exactly.
diagram.
So here is a line of the 20 foot because there's a mark here. It's called 20 foot. You can point that out, 20 foot below.
Okay.
Okay.
Uh,
So yes, both buildings are intruding
okay.
very
And
clearly. It's marked up.
from the photographs taken last week, are the gazebo and the greenhouse still there? This exhibit, Lynn exhibit 1004 for everyone's reference. Do you,
Yes.
okay. Now I'm going back to city exhibit 23. Does the gazebo appear on this one, on the survey map?
No,
Do you know why it doesn't appear?
don't know.
Okay.
I think maybe if you go to the exhibit 9, you just
Mhm.
saw that plan exhibit 9. So this is my theory. Okay. So in this plan, it shows the
Objection,
greenhouse.
non-responsive, speculative, move to strike.
She hasn't even said her theory. I mean, maybe it's based on actual
You didn't
facts. I
ask her
don't
her
know. It's
theory.
premature.
Okay,
Let's
John,
hear
ask me a question then.
Yeah, go ahead,
John,
answer the
ask me.
question.
You gotta let her
Okay.
finish. If you don't like her answer, then you can object and move to strike. But she hasn't finished her answer, and I'm almost done anyway. So I think we should just let her finish.
Yeah, in this
So
case,
Exhibit 9 is one of the submission plan. Based on exhibit displayed by City of Mercer Island, I found out there's many submissions. As I said, this is a very straightforward, simple project, and just build a two building in the backyard. So I believe the city of Mercer Island has made a lot of effort to make the applicant to conform the code, not only the erosion, but also the location of the two building. So from this exhibit 9, this is one of the submittal. It shows that two building is over than 20 foot. This is very obvious in intruding the front yard setback. I don't remember when that, because there's too many submittals. I don't remember. Maybe I comment based on the submission because I commented twice. When I saw the building intruding 20 foot, that's how I raised question. I said the building is intruding the front yard 20 foot because here showed clearly. So I want to add a point. The reason they put that two building like that two building location is pretty much from the survey plan. They just transplanted here. So when we do, I can give you some background since I was engineer for 14 years full time. I have a
Objection,
professional engineer
non-responsive.
license, and it just
Always.
I'd move
happened.
to strike. She's just offering narrative that's not responsive to a question.
Yeah, I'm asking her what this depicts, and she should talk about what she depicts from her experience as an engineer. I don't see how this is irrelevant. I don't see how this should be strictened.
Okay, overruled. Miss Lynn, go ahead.
Thank you, Judge. So that two build. So normally when the engineer design a plan, is first thing they need a survey because no eyeball can show where's the location, where's existing. So first thing the designer need to know what's existing condition. That's number one. So survey. Then move to okay, I want to change the location of the two building. So I believe so when they design this version, they just maintain the same location of the building and show the 20 foot. I hope the city didn't pay attention, didn't see it, and they build it. So of course, city is very due diligent. I so appreciate that. City of Mercer Island is very awesome in the permitting process, and also I provide comments too, so that two buildings intruding at 20 foot, everybody can see that. Everybody can see that the dash line is 20 foot from the property line, the two buildings intrusion. I provided my comments. So now they shrink the building. So in the design part, when the existing building at a certain location, that you build a new location at the side plan, it's going to be very confusing to contractor. They missed one step, which is a demolition plan. Demolition plan, because in the demolition plan, going to show the contractor how that corner of that building be removed. Is that going to be take out the entire building, rebuild a new footprint, or simply chop them off and add two posts? There's a detail. The good plan need to show that demolition plan. So tell the contractor how you're going to take down this side of the building,
Okay.
but they don't
Okay.
have that information in the design. So it's very confusing. Even myself, I was a professional engineer. I read this plan, I kind of lost. I say, where exact the new location? Sometimes I confused with the survey plan as the final plan. But anyway, that's my comments. Demolition plan should be part of it, especially this project is for unpermitted structure on the location. So demolition plan is very crucial because this building already built
Okay.
that need to be relocated.
Okay. So just to summarize, so this diagram, exhibit number 9, this, to your understanding, shows a intrusion into the 20-foot setback, right?
Correct.
Okay. And this is what which, prompted you to be concerned about the setback.
Yes.
Okay. And then now I'm going to go to exhibit number 23, which is the approved site plan. And this one, does it still show the intrusion? Okay. And is your concern, however, how to get from this point to this point from exhibit 9 to exhibit 23? Is that generally your concern?
Exactly. It does
Okay.
not tell how they're going to get there.
And to your knowledge, does the decision address the front yard setback at all?
John, can you say that again?
Yeah, so that this the what they call it, the staff report and decision.
Mm.
To your knowledge, does it even address this front yard setback issue at all?
I don't remember that. I don't think so. No.
Okay.
I didn't say specifically how they're gonna do the um relocate the building. I don't remember it says that.
Okay. I just want to. I'll just briefly pull that one up. So okay, and let's see. This okay. This is city exhibit number 24. I'll pull it up on the screen. Yeah, bear with me here. Thank you. All right, it says staff report and decision. Is that what it says on the top?
Yes, staff report and decision.
Yes, definitely. Sorry. And then yeah, I'll give you a chance to read like 1 and 2 here. Just the introduction.
Introduction. Okay, the project description, the applicant
Or you can just
proposed.
read like with your eyes. I just my question is just
Oh,
that
you want to read
based on
out
what you
out
see
loud? Okay,
here, based
perfect.
on what you see here, does this even talk about the setback at all? So that's just my question.
No, I did say outside of any easement area and also a critical, no, didn't say the front yard 20-foot setback, no.
Okay. Okay. And then, so as far as you know, again, no, strike that, because we already answered that. Okay. So just to wrap it up, ultimately, this decision also states here. Can you read this highlighted sentence?
The new returning wall is proposed to be located outside of any easement area as the previous easement for ingress, egress, and utility has been relocated to follow the existing driveway. Yeah, that's I think that's the main part where appeal here. That was the main point. I think the city of Mercer misunderstood that court order and easement.
Okay, because as far as to your knowledge, this conflicts with the court order. Is that
Correct.
your position? Okay. All
Yes.
right. All right. I think that's it for me. Anything else you want the hearing examiner to know?
Anything else? I think it's just I want to say that because the city of Mercer Island handle a lot of project, I totally understand that this is actually, as I said over and over, is a very straightforward and simple project. And so I'm so sorry for, causing so much time of everybody and here to hear this. But I can see from the applicant to do the plan, they try to sneak in, try to maybe avoid the complete conform to the code. Just think about using the existing building. Maybe say, hey, I don't have to remove it because I don't have a demolition plan. I don't tell the contractor how to demo it, and we can figure it out when it comes. So I think it's very important for city of Mercer Island to put some requirement in the final permitting document, which is reinforce the location of the two buildings, because that's the whole purpose. As I said, without bare eye, you would never tell the building is in the setback, in the easement, or not. No idea. No. You could not tell. So I think it's very important to put some requirement in the final approval about how to comply, how to reinforce the compliance. Either this, I know the city of Mercer Island might have a lot of method. Maybe ask her applicant to provide a final as build survey to show exact location of the final building location and the returning location, everything location, and show all the background, the easement mark on the plan properly. In that case, then we can make sure this project is done correctly.
Okay. All right. Thank you for your time. And thank you, hearing examiner.
Okay.
That will conclude our presentation.
Okay. Well,
Thank you, everybody.
oh, just hold on a second. Mr. Weiss, did you have any cross-examination?
Yes, I do. I don't know if you would like the city to go first if
Oh,
they have
if
questions.
that's your preference, I mean, yeah, I usually have the city do cleanup after, but if Ms. Kiefer, did you want to go first?
I can make it really easy. I don't think the order is necessary. I don't have any questions for Miss Lynn.
Okay, that makes it
Thank
easy.
you.
Ms. Weiss, okay, Mr. Weiss, any questions?
Yes.
Okay.
So good morning, Miss Lynn.
Good morning.
You and your attorney keep referencing a middle easement. You recall that? my question for you is, what legal document creates a middle easement?
Objection. This is a cause for a legal conclusion. It's already resolved by the court order of 2021.
All right. Well, I'll overrule Ms. Linton has already testified about her understanding of what the middle and the side easements are. So it's a valid question. Go ahead, Ms. Lynn. And I'm sorry, Ms. Lynn, did you say your last name is pronounced Linny, or am I
Melina
mispronouncing?
Lin,
Sorry, Lean?
Lin.
Okay.
Yeah, Lin.
Okay. Yeah, go ahead.
Okay, so I'll ask again, what document creates a middle easement?
Morgan, I think that question is really to my lawyer because I don't have all the easement in my hand tip. But I understand my lawyer John has done a lot of good work about coved out which document and is in the brief. I cannot tell you which document, but I know I have easement in the old driveway.
Okay, how do you
Specifically,
know
which
that?
document I cannot tell you. I'm so sorry.
No,
John,
so
maybe
so
you
you, no, answer my question. You're deferring to your lawyer. You're the
can.
witness. You're the one who presents evidence. Why do you have a middle easement? Why do you believe you have a middle easement?
Because I can answer that question.
You cannot?
Because I can't. I
Okay,
can't
please do.
answer that question. Yeah. So there was an old driveway.
Right,
That was my old driveway easement to get out to the street
right.
on my neighbor's property. So under that driveway, there was a utility buried. Probably not just water line, maybe some other things too. I have not verified. Maybe there's an electrical line, maybe there's cable, Comcast, and telephone.
Sure. And you're
I
speculating
don't know.
about all that. You don't actually
I'm not
know.
speculating. No, hold on. No, no, I'm not. I'm not at all. There's old driveway, that location showed very clearly is a dash line. So, and also there's a utility under there. And I'm not speculating. It's because I had it down twice. Water line locate is just right in that territory. So that's my
Okay.
easement, utility easement. Has
So,
not been relocated to under the new driveway. Sorry.
so Miss Lynn, we can agree that there was 15 years ago a driveway that went through the middle of the property. You agree with that and you understand that, right?
I'm sorry. 15 years ago, the driveway middle to the middle of the I'm sorry. Can you explain more? What do you mean middle?
It through the garden area. You're the one using the phrase middle easement, and you're describing an old driveway. And so you and I think we can agree that 15 years ago, there was a driveway through the middle part of the property where this area you're calling an easement is. Is that right?
When you say 15 years ago, that's before my neighbor's house was built. Yes, that's old time, before I even bought my house. Correct.
And I will also object just for the record. I object to the line of question for relevance because, as established in the 2021 order, the driveway easement is separate from the middle easement. We're not talking about the same thing here.
All right. Overruled, but I think, yeah, if you could be more clear about your, distinction between the easements, Mr. Weiss, that could help.
Well, that's where I'm trying to go.
Okay.
So we agree there was a driveway there 15 years ago, right, Miss Lynn?
Yes.
Do you believe that there was a easement for the driveway 15 years ago?
Which driveway? The old driveway? The middle one?
Yes, ma'am.
There is one. Yes, there was one. Or
What legal document creates that easement for the old driveway that existed 15 years ago?
again, Morgan, you asked me what document. That's really a lawyer's question. I hired my lawyer, John's, telling me which legal document. I know the
No, no,
facts on the ground. I'm not a lawyer. Which document? I defer to the John again.
no, 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 no.
Plus doesn't have to go there. As John said, we already have a court order in 2021, a rule that
No,
easement, all got all the past to figure it out. So I don't know why we have to go back original. It's just like we already have a court order. Why we have to go back to question about that court order? This is what you're trying to do.
Yeah, that's one of the primary arguments in this case, Ms. Lynn. But if you don't know the answer to a question because it's legal, just say I don't know. I mean,
I don't know. Legally, I don't know. Yeah,
yeah.
thank you. Thank you, Judge. Help me.
So, Miss Lynn, you've testified for about the last 45 minutes that there's a middle easement, but you don't actually know what this middle easement's based on. You don't have any personal knowledge of a middle easement. Is that correct?
I will object because that actually is because she already established that she has personal knowledge in City Exhibit number 43. It's a declaration by Lena Lin. That was a signed exhibit presented before the court in the 2021 order matter. It sets forth all these facts that you're looking for in great detail. So that's already addressed.
Okay, overall, go ahead and answer, Ms. Lin.
Thank you. I know from what John said, the document, the court order, I know I have easement.
Miss Miss Lin, I'm going to do a screen share here of the city's Exhibit 46. So give me a moment, if I may. So for the record, I'm screen sharing City's Exhibit 46, and I'll scroll up to the top for the benefit of the parties and hearing examiner. But this is the short plat for the properties filed in 1978. So this page 1, I'm scrolling down to page 2, which describes parcel A, parcel B. And then when you scroll down to what is page 4 of 7, it shows a map of the short plat. Miss Lynn, can you see that I'm screen sharing?
I can see the screen sharing, yes.
Okay, fantastic. Miss Lynn, do you understand that this is the legal document that subdivided your property and Can Chu and Tammy Lou's property?
I cannot answer that question because that's one of the title document. My property has about like a 150 page of the legal document easement. I scratch my head.
Okay.
That's one of the document. That's what I can answer your question. What's the
Do
purpose?
you-
I don't know.
Okay. So you don't know the significance of this document that I'm screen sharing with you right now.
No.
Is that correct? You don't understand what this
I say
document.
no, I don't understand significance. I know that's one of the document. I saw that similar thing in my title document, but I don't, yeah, correct, no.
Okay. Miss Lou, do you see that? And unfortunately, the quality is rather poor, but do you see that down here at the bottom? Does this, you see it says drive and utility easement along the southern portion of this depiction? Do you
It's
see
very
that?
hard to read, but I think I agree with you. Say drive and the utility easement, correct.
And over here, do you see where I'm highlighting the word new?
I cannot tell, that's new. It's hard to
Okay.
tell.
Yeah,
Cannot
unfortunately, it's
read.
poor quality. I'm going to highlight another portion here, and it's a dashed line consistent with the prior exhibits you and your attorney have shown. And it's handwritten in there, and it says existing drive. Do you see that?
I can see existing drive, yes,
Okay.
sir.
And you agree that's where or it's your understanding, because you don't actually have any personal knowledge, but it's your understanding that that's where the old driveway existed 15 years ago.
Honestly, I cannot tell because the driveway may be changed again and again. I don't know.
Okay, you don't actually have any personal knowledge of the condition of the property before you purchased it. Is that correct?
No, I
Objection,
have no.
condition of the property is vague. I mean, are we talking about the title? Are you talking about the land, whether there's any defects? I mean, what's the condition of the property?
Okay, rephrase, Mr. Weiss.
Okay. The physical, you don't have any personal knowledge of the physical existing condition of the property before you purchased it. Is that correct?
When I bought the property, I did inspection and I reviewed the title document, but title is so headache. That's so far I know. But before that, I have no knowledge about this property, not so ever. No.
What year did you purchase the property?
Let me think. 2017 September. I think I might be right because that's a while ago. Yeah, 2017.
Okay. So prior to September of 2017, you had never been on this property. Is that correct?
Yeah, not before I know it was for sale. No.
When you purchased the property, the driveway did not run through the middle of the applicant's property, correct?
Correct. Is that
And
the
in fact,
existing now location? Correct.
okay. In fact, as long as you've lived in the property, the driveway has remained in the same place, right?
Correct.
You had the water line located in November of 2021. Do you remember that?
I know. I don't know the date exactly. I don't have a record, but I think yes, I did one time locate. Yes.
I'll represent to you it was in November of 2021.
Yeah. If you can show me that invoice, then I can confirm. I
Okay.
hired a
Well,
CNI.
and when they went out, when the utility locate company went out there, they put blue marks on the ground, correct?
They sprayed on the ground. Correct. Correct.
Did you go onto the property that time and observe the markings and condition of the property?
That time I did went to the side. I did because there's nobody coming out from my neighbor's house. Not like this time. They're like they got an army come out when my contractor come to locate. But the first time it was quiet. They agreed to the date. Now I just went in. I did. I did went to her property.
Miss Lynn, I'm showing you a photo or
Mhm.
screen sharing a photo that was taken from November of 2021, the first time you did the utility locate.
I'll object to this just on the ground that I have not I don't believe this has ever been provided in the exhibits that has to be submitted in time. So this is something new.
That's correct. And I'm asking the witness about it because she was there, as she
Yeah,
just
but I don't think you
testified.
can ask because it wasn't submitted beforehand to the hearing examiner and to us and to the
Oh.
city.
Yeah, I mean, all exhibits were supposed to be presented about a week in advance, Mr. Weiss. Why is this coming up?
Well, frankly, because I didn't know to look for the prior photos until we got their exhibits when she did the utility locate on the 19th. Literally 8 days ago, they gave us the photos that they took. So I'm looking at the comparison photos from 5 years before, if that makes sense. So I'm understand. I just want the hearing examiner and opposing counsel to understand that I'm not trying to spring this. It's that we didn't have photographs of the area prior to a week ago.
So where did these come from again? This was you're saying this was a locator done several years ago, or I'm
This
just trying to understand
That's
what.
correct. This was the same contractor that Miss
Oh,
Lynn contracted with in November of 2021 to do the exact same thing they did a week ago.
okay.
So the deadlines are set forth in the Mercer Island rules of procedure. They're known to everybody. We all abide by them. This is untimely. I move to strike.
Yeah, and so, Mr. Weiss, you're saying you got these for the first time when, and why did?
Well, no, they've in full disclosure, these have been in my archived file for 4 or 5 years since
Okay,
Miss Lynn was litigating a separate issue. And I didn't know that it would be germane to this hearing until we got their utility locate that took place 8 days ago.
okay,
So I want you to understand, I'm not trying to pull a fast one here or anything. It's just that I didn't know the relevance or significance of 5-year-old photographs until I got
and so why
eight
is
day.
this? So why is this relevant to the more recent locator photographs you got? What's the purpose?
Well, it's going to show the before and after conditions. I mean, council's making a big
Oh,
issue of the retaining wall, the location of the water line, which I refuse to call an easement. He's making a big deal of the water line. And what I'm saying is we've known for 5 years where the water line exists, and Miss Lynn's known for 5 years where the water line exists. Um, so I want to show the condition of the property and that it's previously been marked and measured.
okay.
We have
Well,
not seen this photograph before, so it would not be fair to us. It'd be highly irregular to spring this on us. This is literally like trial by ambush. We move to strike again.
Well, I'll supplement the record.
well, no, okay. Yeah, I think. I mean, the issue of what the property looked like before was an issue before you knew about the most recent location. I don't see that the most recent location really creates the need for this photograph, nor that it's highly provides, something highly probative. So I'll sustain the motion to strike.
Understood. Okay. Give me a moment here. Here we go. Miss Lynn, I'm screen sharing with you a photograph from the CNI declaration, which is your exhibit number 1003. Do you see that? I'm sorry to hear your answer.
Yes, I
Okay,
see it.
thank you.
Yeah.
Is it your testimony that an employee from CNI took this photo? I still didn't hear an answer.
Sorry, did I?
Did
Can
already
everybody else hear me? Is my too low voice?
Yeah,
I need
we
a
cut out there.
cut out. Yes, CNI took those photos.
Okay, I'm just gonna. So that was the first in the series of photos. I'm gonna scroll down. So second, third. So I'm looking at 1003.06 photo here that I'm screen sharing. Is it your understanding that the blue line depicted on the ground there is where the water line goes? Is that correct?
Correct.
And based on this photograph, it appears to go under the cinder blocks that are depicted there. Is that right?
I don't know. Is any blue line under there?
I don't know. I'm asking you.
Yeah, there's blue line on there. Then that's where, yes, that's
Okay.
a line continuous. Yes.
So I'm screen sharing, and I'm just verbalizing this in the event I think this is recorded and on the record. But so photograph 1003.07 shows the blue flags, blue paint, and they're on either side of what appears to be a sloped, some cinder blocks in the ground. Do you see that?
Yes.
Is this what's depicted in this photograph? Is this the interference that you're concerned about?
I'm concerned about the interfere the completely the size of the easement because I have a legal right, which is I believe is 10 foot wide of the older driveway as easement.
Okay, so let's go back to that because that's what I started asking about. What's your knowledge of this 10-foot wide easement based upon? Because you're testifying about it again. What's that based on?
This was from an old driveway. The utility was under an old driveway.
But
That
was
should be
there,
the easement.
okay, Miss Lynn, was there ever a utility easement through the middle of my client's property?
objection calls for
Yes.
legal conclusion. Res judicata is already resolved in 2021 order. We're not relitigating this. Besides, there actually is no jurisdiction before this tribunal to even adjudicate that issue, which is already adjudicated in the correct tribunal, the Superior Court.
I would like the witness to answer. If she's going to testify to certain facts, then she needs to answer.
Yeah, she's already testified about her knowledge about the easements in the appellant's direct testimony, so it's fair to cross-examine her about that knowledge as well. So please answer the question, Ms. Lynn.
Miss Lynn, what's your knowledge that there's a utility easement located, what's depicted here in Exhibit 1003.07? What's your knowledge about an easement based upon?
Based on the court order under the old driveway. That's my utility easement called the middle easement.
Who called it a middle easement besides your lawyer? Who calls it a middle easement?
My lawyer in the brief for the convenience of the reference.
Sure. Did Judge Siegel call it a middle easement?
No.
Okay. Does the short plat that I'm again sharing with you, does it call a middle easement?
No, I don't think the names matters. Location of the easement is matter the most. The
Well, so
name
let's,
just for easy reference.
sure, I'm screen sharing the short plat again, which is City's Exhibit 46. Um, under the part that I highlighted that says existing driveway, does it say anything about an easement?
Yes. It says
Oh,
drive and the utility easement.
right. And it says that on the south border of the property, correct?
I disagree. The driveway is continuously.
Well, but I highlighted the word new also. It says new drive and utility easement.
I cannot answer your question.
Yeah. Give me a moment here. So I have to go back to my previous document, and the screen share function is hiding it. Okay. Um, what is this? Okay, two. Sorry, a little clumsy with the technology here. So, Miss Lynn, we were looking at photos 1003.07 and also 1003.06. Right in the foreground, in front of these planter boxes, and there's some PVC pipes. There's a two cinder block brick tall hardscaping. Is that what you're referring to as the retaining wall?
Hard to tell. I cannot tell. I don't know. I guess
Well,
it
well,
is.
well, well,
I
you're
can say
calling it a
it is.
retaining wall, and you're saying that this retaining wall is interfering with your easement. Is that right? I didn't catch your answer audibly. I saw your mouth.
Yes.
Okay, thank you. Okay, what's a retaining wall?
Retaining wall is a wall to support the soil.
Sure. And since, I mean, you're an engineer, so is something that's 6 inches tall, is that a retaining wall?
I cannot answer the question.
Is something that's 12 inches tall a retaining wall?
I cannot answer that question. It's depend on the situation. You have to show me the paragraph, the plan
Could we agree that something
section.
that's 10 feet tall, that would be a retaining wall?
I cannot answer that question.
Okay, so you don't know what height a piece of stone or cement in the ground becomes a retaining wall?
I cannot answer a question without a look at the plans, returning wall or not. Cannot, I cannot.
Okay, so you don't know if this is a retaining wall or not then.
I know the wall here is returning wall
Well,
because
why?
this is built on the ground already.
Okay, so at what height does cinder blocks placed on the ground become a retaining wall, Miss Lynn?
I think any rock which is a support the soil to prevent the soil or to support the soil as can be a returning wall.
Okay. Let me ask you this. Would it be your preference that there be nothing retaining the soil so that it all just runs, like when it rains, the soil just runs down the driveway?
Objection assumes facts not in evidence. I mean, how do we know that any soil will run over? We don't know that.
I don't understand the objection, so I can't even rephrase my question.
Yeah, go ahead and answer, Miss Lynn.
Can you ask again?
Yeah. Wouldn't you prefer there be a retaining wall or some kind of structures to prevent erosion and preventing the dirt and soil and mulch from running down the driveway into your yard?
I prefer nothing there so that I can access to the easement when I need to access. I just return that part of the soil back to the condition to build a returning wall, like the photo you showed us. It was dragged out. I do not see any returning wall on that yard. That's natural state of the soil. It's not
Um,
gonna go
you, you,
anywhere.
you say so you have access to your easement, but I'm just not understanding why you think you have an easement.
Objection argumentative asked and answered.
No, I mean, you're calling it an easement, but no legal document calls it an easement.
Okay.
So what?
I cannot answer the question. I thought that question has been answered many, many times
Yeah,
already
yeah.
by
Yeah,
the
it's
court
badgering the
order.
witness at this point. I mean, yeah, it's just again same question over and over
Let's move
again.
on to the next
It's the
question.
same question.
That's the next question.
Okay. Miss Miss Lou, or I'm sorry, Miss Lynn, the water line when you had it located both 5 years ago and 1 week ago went under a chain link fence. Is that fair? Or is that accurate?
I have to go back and look at the photos. It seems
Well,
like a yes, close to the
okay.
chain fence.
Well, you
That
drive
photo,
your
you show me
driveway
the photo.
multiple. Oh, I'm sorry. Go ahead. I didn't mean to interrupt.
I answered your question.
Okay. There's a chain link fence that the water line goes under, correct? It's not a trick question.
I'm not sure it's right on top or is close. Yeah, there's that shrub. hmm
Right?
Correct.
Okay. As depicted in picture 1003.07.
hmm
Is do you object to there being a chain link fence?
I think if they can remove it, that's great.
Does it obstruct the water line?
It seems that it does now. Yes.
Pardon me?
Yes, it does interfere with water line.
How?
Look to me, the fence is right above the water line.
Now you don't need access to the water line, do you?
I need access to the water line.
Why?
Water line is utility. It can be leak, can be broken down. I need maintenance. So I do need access to my utility easement
Well, you
and the
you
water
previously
line.
signed a declaration where you actually can just replace the entire water line, your contractor can, and just do it all, I forget what they call it, like surface drilling, where they just go under, right? Do you remember that declaration you signed?
Objection. I'm not sure what declaration you're talking about.
Well, I'm not asking you.
Yo, which declaration, Mr. Weiss?
Yeah, but you have to be facts and evidence. Which declaration?
Sure. No, counsel, you submitted it.
Okay, well let's take a look.
Pardon me, give me a moment.
Do you have a lot more questions, Mr. Weiss, or because we're at the 90-minute mark? But if you're almost done, we might
I think I'm near done. I'd
okay,
prefer to
be done. Yeah.
be done. Sorry, you know what? How about we take a break?
Okay, we'll take it now. Take it till 10:48. We'll see you then.
Okay,
Sounds good. Thank you.
thank you.
Back on the record, February 27th, 2026, at 10:48 a.m. on the Lynn versus Mercer Island appeal, still in cross-examination of Miss Lynn. So go ahead, Mr. Weiss.
Sounds good. I'm going to do a screen share again. Miss Lynn, before we took a break, I was asking about a prior declaration that you did. I'm going to scroll up in fairness to you and counsel. And for the judge and counsel's reference, this is actually City's Exhibit number 43. So City's Exhibit 43 is a declaration of Melina Lynn. It was filed with King County Superior Court, according to the stamp, on October 8th, 2021. it also includes exhibits A through G. It's 46 pages long. So, Ms. Lynn, I'm going to scroll down just so you see what I'm talking about. So, on the bottom here, rather, page 4 of your declaration, it's dated October 8th, 2021. Do you see that, Ms. Lynn? You're muted, ma'am.
Yes, I see that. I'm so sorry. I'm
No
muted.
problem. So, Ms. Lynn, do you remember signing this declaration?
If it shows that, then I must have signed it. Yes.
Okay. I'm reading from paragraph 12 of the declaration, the part that I highlighted in yellow. It says, quote, I plan to install the new line at the same location of the old line within that easement using trenchless technology. The contractor will only need to dig 2 to 3 holes, one at the end of each straight segment of the planned line. Then they can pull the new water line from the hole to the other. This would have had minimal to no impact on plaintiff's property. As I understand it, there will probably 2 to 3 holes to be on plaintiff's property to pull the new water line through. The rest of the line would have been on my property. Did I read that correctly, Miss Lynn?
Yes.
Okay. Now we were looking at the photograph previously of, okay, what is exhibit 1003.07, and you indicated in your testimony today that the cinder blocks and the chain link fence would interfere with your ability to use or maintain the water line, but your declaration here says it can all be done with trenchless technology. Is that right?
So I want to correct a point.
Okay, go
So,
ahead.
okay, back in 2020 or 2021, yeah, 2020.
2021.
Okay. Yeah, the time wise, sometimes okay. At that time, I was required to need to upsize my water size. So I tried my best to be the good neighbor to my neighbor. I want to have a minimum interference into the yard. So I contact a different contractor. And because I'm in real estate, I have done a couple of jobs. They can do trenchless in the sewer line. They can liner. The sewer line is very large. It's about 4 inch to 8 inch. So they can some lining inside the pipe. Then I find this contract. Now I recollect my memory. But in my career, I never done like a trenchless for a water line. Water line is very small. It's only 1.5 inch or one quarter inch. I never done in the real life. So when I wrote that statement, I was trying to be a very good neighbor, minimal impact. But even so, that can be done. But I cannot give up my right of the easement on my on the neighbor property, even though the line is using that method to install even backward 1,000 step. I still need access to maintain the new line. But by the way, luckily, it proved my line actually does not need the upgrade anymore because it's proved my line right now is 1.5 inch or 1.25 inch, so it's large enough. So that job was jobbed. I never did that job. The job was never happened because I hired the plumber, checked my existing water line is big size enough. So that point I don't need access for install the new line anymore. But it
Okay.
doesn't matter what, I need access to maintain my water line. For example, right now I have a leak line, the water leak. My neighbor refused me from going there. If she had not refused me that hard about 4 years ago, maybe I don't even realize this is an issue.
Okay. But the Can, Chu, and Tammy Lou have allowed you to come on their property twice to spray paint it with blue lines and flag it where the water line is, correct?
That's correct. That's only
And
after
hold on,
twist
so you've
the
answered my
arm,
question.
twist the arm, tried so hard. I can show you all the email if you want to
Okay,
see it.
no, I've seen
Back
them,
and
ma'am.
forth, coordination, 2 weeks, just for that minimal access on the outside of the yard, not inside the house. I said, you don't have to be there, but there, I
Ms.
don't know
Lynn, I
what
want
they're
to ask you
worried about.
another question.
Go
Can I
ahead.
ask you another question now? Uh, you also had somebody come in January and they were testing on my client's property, and your niece was there and my client was there, and they were testing for leaks on their property, right?
Yes,
Okay, so my client has in fact allowed you to get on the property to use and maintain the water line on at least 3 known occasions, 2 within the last 2 months, right?
yes. After I tried so hard,
Now,
twist the arms.
you
I
agreed that
imagine
you
I don't
would.
have easement. They're gonna shut the door down, so no, you cannot access. I know that for a
Okay.
fact.
One of the conditions was that you would not use the photographs or take any videos of the property for use in litigation or this administrative hearing, right?
I'm not sure what you're saying.
Okay.
I don't know. I don't understand that.
It seems not. Did you trespass on my client's property at any point?
No,
Were you taking any photographs on my client's property?
I took some photo from the driveway.
Did you take any videos on my client's property?
Yes,
Okay. And in fact, you submitted one of those videos as part of this hearing, correct?
I don't remember, probably.
Um, Let me screen share again. Oh, I am screen sharing. Pardon me. This is a video that it's exhibit number 1012. Do you see my screen, Ms. Lynn?
I do.
Is this, and I'm playing it, it's just like a 11-second clip. Did you take this video, Ms. Lynn?
I did.
Okay. I'm gonna play it again. I'm actually just gonna, I want to establish something and be very clear to our hearing off or administrative law judge. So I'm pausing it at the 10-second mark. Now, where it's paused at the 10-second mark of exhibit 1012, it shows a pretty substantial retaining wall and it shows the pergola. Do you agree with that, Miss Lynn?
Yes.
Now, none of the area depicted in this paused image is in or near the water line, correct?
In the backyard.
Right, but this is nowhere. This area in the foreground with the retaining walls and the stair and the pergola, this is not even within 15 feet of the water line. Is that right?
Objection. Just want to seek clarification. You're talking just for the record, really. This you just talk about just this particular screenshot, right? The 10th minute of Lynn exhibit 1012, right?
Correct, yes.
Okay, yeah, go ahead.
I just want to say what's being depicted at the 10-second mark here, none of this is at issue, other than I understand your contention about the pergola being within 20 feet of the property line. I do understand that, but this retaining wall, as constructed, this is not near the water line, correct?
Probably is not.
Okay. In fact, let's see, I'm gonna. At the 5-second mark, um, the video is pointed kind of to the corner where you can see a white pot. The water line's more in the area depicted at the 5-second mark. Is that correct?
Right. But I think need a survey to finalize. But you're right.
Okay. Um, Stop share for a moment. Miss Lynn, you said you took this video from the driveway?
Yes.
the common driveway or not?
Around the driveway, I don't quite remember. What's your point?
Well, I'm getting there. Miss Lynn, I'm showing you what are essentially ring camera photos. Is that you there with the red boots taking a video?
Is this an exhibit?
No,
Yeah, I'll also object because this is also not provided in the exhibits by the applicants.
you're right. It's impeachment. And so I don't have to submit it ahead of time.
Well, this is a response to her video? Is that correct, Mr. Weiss?
That's correct. This is literally
Okay,
a
all right.
photo
No,
of her
it's
taking the
actually,
video.
I mean, I admit it as rebuttal essentially, but not impeachment. But yeah, it's admitted as rebuttal.
So, Miss Lynn, I just want you to confirm, is this you in the red boots taking the video that we just watched?
Yes.
Okay. Did you have permission to enter onto my client's property and take videos? I know the answer to this question, and so do you. So you can answer it.
Objection, because you say on my property. I have to clarify. This is very important for the record. You said for my client's property. Well, the whole any place that's an easement is technically your client's property. So I need to clarify. Are you talking about an easement area or just your client's property in general?
Miss Lynn, do you understand the question?
Not really.
Okay. Did you have permission to enter onto my client's property, not in the easement area, and start taking videos and photos?
My neighbor never permitted me do anything near to their property, not access to the easement. So my neighbor never say yes. So the question for you is no, that's exact the problem about this appeal. Normally, I would not go so far about this type of easement, but yeah, you ask a very good question. No, my neighbor never allowed me.
Thank you. I just want to point something out. In your declaration from October of 2021, Ms. Lynn, again, it's Exhibit 43 of the city. You attached to that as Exhibit A, the short plat from 1978. And I'm scrolling down just to, oh, I'm sorry, I'm not screen sharing it with you. I don't want you to think I'm misrepresenting something. So again, I'm screen sharing Exhibit 43, which is your declaration. So you see that here. So Exhibit A to your declaration from October of 2021 was the 1978 short plat. Do you see that?
I see the screen. I see the screen.
Okay. Well, I asked you about the 1978 short plat earlier, and you said you didn't know anything about it, but you do you remember that?
I say that I don't remember exactly which easement document because my house has about like a 200 page of the easement, has a lot of 1978, 79. I don't recall any particular one unless I have to go back to do the homework. So I still don't know what's this page.
Okay.
It's very confusing of my easement, my document. That's why I hired a lawyer.
Right. Um, I just want to point out to you and to our hearing examiner that you've already provided a sworn declaration about all these documents. Miss I'm sorry, Miss Lynn, I'm asking about, let's see, this is Exhibit C to your declaration from 2021. And it appears to show the survey that was done in this case. But I want to talk about the easements that are talked about in here. Can you see the document, ma'am?
Yeah. Yes.
Um, can we agree that in all the property documents and title documents that there is an easement along the southern border, which I'm highlighting yellow on this. Can we agree that there's a easement there?
I agree, but any legal question about how to interpret this easement document, I have to defer to my lawyer.
Okay. Ms. Lin, can we agree that there is also a utility easement along the northern border of my client's property that I'm highlighting yellow?
I can say yes, but I defer that to my lawyer.
Okay. Now, you earlier testified that parts of the retaining wall were built into the northern easement. Is that correct?
I'm sorry, you repeat the question again?
Yeah, when Mr. Yip, your attorney, was asking you questions, you had testified that you believe that parts of my client's landscaping were built into the northern easement area. Do you remember that testimony?
Yes, I believe so, because based on the
Okay.
survey.
So you can agree that there's a northern easement. Is that
Yes,
right? Do you also agree that there's a southern easement?
yes.
Okay. And do you understand that the southern easement is for utilities and ingress and egress?
I cannot answer the question. I believe for easement.
Okay. Ms. Lynn, I don't think I have any other questions for you. Thank you for your time.
Okay.
Thank you.
Ms. Kiefer, still no questions?
Correct. No questions. Thank you.
Okay. And Mr. Yip, any redirect?
No, no redirect.
Okay, Ms. Linton, I think you're finally done. Thank you for your testimony. Very helpful for us today. That's great. All
Thank
right.
you, Judge.
Yeah, thank you. And Mr. Yip, I understand that this was your one witness for today, correct?
Yes, that's
Yeah.
our one witness. Yeah.
Okay, so let's move on then. I think that the next, yep, according to the rules, is the city at this point. Ms. Kiefer, any witnesses you want to present?
Yes, and I have a very brief opening statement before we
Sure.
get into our one witness, just to reframe us after, about 2 hours. So, good morning, hearing examiner, counsel, and parties. As you've heard extensively this morning, this case is an appeal of two land use reviews, a critical area 2 review, and a building permit. I think it's uncontested at this point that there is no real appeal point about the critical area 2 review. So in the interest of time, the city's not going to address that land use review. So that really brings us to the building permit. And I think based on what we heard today from appellant's case as well, that essentially we're all in agreement about structures within the required setbacks. So we heard and we will hear testimony that this is a permit to relocate a few unpermitted structures, gazebo, greenhouse, and retaining walls. And as the structures will be reconstructed, not as they are today, they will be located in conformance with required setbacks. And we will present testimony as well to show that as the permit works, once the work is complete, there will be an inspection and that will verify that the structures are not within required setbacks. So the city does believe the permit decision as issued on the setback question is sufficient. And then finally, I think we can all agree that the largest issue in this appeal is the question of whether there is what appellant calls the middle easement and where that easement is located and what rights that involves. I will say that this is something that the city had asked applicant about in testimony will show that the city had asked applicant about this in the context of reviewing the building permit. The city issued the building permit in good faith on reliance upon materials provided by the applicant. And the city's entitled to do that. But during the preparation for this appeal hearing, the city did discover new information, including the 2021 summary judgment order we've heard about this morning. And that new information has really put applicants' assertions regarding what they call the middle easement into question. So the question before the hearing examiner is really going to be whether he agrees with the appellant or with the applicant. If he agrees with the appellant, then what is appropriate is a remand of the building permit for the applicant to revise to move the retaining wall outside of the easement. But if the hearing examiner agrees with then he should uphold the city's permit and critical area 2 review and dismiss the appeal. And with that, I will call the city's first witness, who is Grace Manahan.
Ms. Manahan, I'll have to swear you in. Let's see if I can see you out there. There you are. Okay, just raise your right hand. Do you swear or affirm to tell the truth, nothing but the truth in this proceeding?
I do.
Great. Okay, all right. Go ahead, Ms. Kiefer.
Thank you. Okay, Ms. Manahan, can you tell us what your title is with the City of Mercer Island?
Yes, I'm a code compliance planner.
Okay, and how long have you held that position at Mercer Island?
I've held this position a year and a half.
Okay, and before you were a code compliance planner, were you still with the city?
Yes, I was a assistant planner at the city for 2 years prior.
Okay, and do you have any education or experience or education that is relevant to your job as code compliance planner?
Um, Prior to being with the city of Mercer Island, got a degree in landscape architecture from Washington State University.
Okay, great. And I apologize if I missed it earlier. In total, how long have you been with City of Mercer Island?
Oh yeah, just over 3.5 years.
Okay. And so review of building permits, is that something that you would typically do as part of your role as code compliance planner?
Yes.
Okay. How many do you think that you've reviewed over the course of your 3.5 years with the city?
I don't know the exact number, but over 100 at least, if even a couple hundred.
Okay. So it would be fair to say they're pretty routine for you.
Yes, very.
Okay. And were you the assigned reviewer for the building permit subject to this appeal?
Yes.
Okay. Okay. We heard a little bit about setbacks earlier, Miss Manahan. Can you just sort of explain how the Mercer Island City Code treats setbacks? Does the code often refer to setbacks?
Yeah, so the code refers to required yards, which have specific setbacks for front, sides, and rear.
Okay. I'm going to pull up, it is City Exhibit 23. Let me do that real quick. Okay. Miss Manahan, are you able to see my screen?
Not yet. Yes, now I can. Yes.
Okay, great. And does this appear to be Exhibit 23?
Yes.
Okay, and just to refresh the memory, Exhibit 23 is what?
The approved plan set.
Okay. And so this first page, I think we heard Ms. Lynn testify about it. Was she correct that this is just a survey provided by the applicant?
Yes,
Okay, so does this shows conditions on the ground at the time of the survey, but not necessarily what's been approved?
correct.
Okay, so I'm gonna uh, scroll down here just a bit. I'm sorry, I'm trying to scroll slowly to keep keep folks from getting seasick. I'm gonna zoom in a bit here. Okay. So, and I'm going to scroll over on this page, the enlarged site plan, sheet number A 0.2. Can you explain what this sheet shows?
Yeah, this sheet shows the approved configuration of the proposed improvements as well as you're just on like the detailed of the retaining wall and then as well as tree protection fencing, I believe is the extent of what's shown on this page.
Okay, great. And so, just to orient us, you can see my cursor, right?
Yes,
Okay, great. So I'm circling this. So this would be this is marked 8-foot greenhouse. Is that correct?
yes, that's correct.
Okay. And does this show how the city has approved the location of the greenhouse to be moved?
Yes,
Okay. And so this structure, just to the side of the greenhouse, there's an arrow pointing to it. Can you tell us what this building would be?
yes, that would be the gazebo where it is to be relocated.
Okay. And the gazebo seems to have a dashed line around it, but the greenhouse does not. Can you explain why that is?
Yes, yeah. So the dashed line surrounding the gazebo indicates an eave, or a small overhang of the gazebo. The greenhouse does not have a eave, and so it does not have a light dashed line to indicate that.
Okay. What does the code say about eaves? Are they able to intrude into required yards?
So eaves are allowed to intrude into front and rear yards and also side yards, but only when it's not abutting an interior lot line.
Okay. And so here it looks like the gazebo you've testified is the structure that has the eaves. And it looks like the only yard that the gazebo abuts is the front yard. Am I correct?
Yes.
Okay, okay. And so we've got a note here. Can you just read this note for us,
Yeah.
Miss Manahan?
Per MICC 19.02.020 C3A, eaves shall not protrude more than 18 inches into any required yard.
Okay, thank you. So as I read this plan, it looks like the city has approved a location where the eave has to comply with the Mercer Island City Code. Is that correct?
Yes, that's correct.
Okay. And as I understand the permit too, the permit has been issued, but the work hasn't been done. Is that right?
Correct. The permit has been issued, but to my knowledge, the work has not started to relocate the gazebo or um, greenhouse or any of the other improvements.
Okay. So absent an appeal, when the city issues a building permit,
Mhm.
that authorizes work to proceed. Is that right?
Yes, that's correct.
Okay. So then what's the next step?
Yeah, so once the building permit is issued, the to get technical, it's a little out of my wheelhouse, so I'm not going to speak too much on it, but there are like pre-construction meetings and other construction meetings that are required throughout the process, that I'm not personally involved in, but the owner can start work and then start completing the required meetings and steps to complete the permitted work.
Okay. But I guess from the city's standpoint, is a permit complete just because it's been issued?
No, it then becomes an active permit, not a final permit.
Okay. And so what I'm getting at here, not very elegantly, is will there be any checks that the applicant has built the structures according to the plans?
Yes, yeah. So the permit will become active, work can occur before the building permit's finalized. There are final inspections that occur to confirm that the work was performed in compliance with the approved plan set.
Okay. So just as a hypothetical here, Miss Manahan, if the gazebo is constructed and let's say the eave protrudes 24 inches into the front yard, first of all, that would violate the code, isn't that right?
Yes, that would violate the code.
Okay. So if an inspector finds that, what would happen?
Yeah, if that the inspector finds that it was obviously not obviously, but that indicates it was not built to the approved plan set and that needs to be revised prior to building permit getting the final for the building permit.
Okay. So the building permit wouldn't be finalized if the what's built doesn't meet the plans. Is that right?
Yes, that's correct.
Okay. Thank you. I'm going to stop sharing real quick. Okay. Ms. Manahan, we heard a lot this morning about easements and easement rights. Can you just tell us generally what the city's role is with respect to easements when they're shown on submitted plans?
Yeah, so once the plans are submitted and reviewed and easements are identified, the city or reviewer will identify what type of easements are present and then coordinate with the code and what the code says regarding that specific type of easement, whether it be ingress, egress, or utility, and confirm that the improvements are in compliance with that applicable code section.
Okay. Okay. And so when you were reviewing the building permit in this case, did you identify what appellant has been calling the middle easement?
Yes.
Okay. And so when you identified that, what happened next?
Yeah, so I identified what I'm going to continue. I'm going to also refer to it as the middle easement. Um, I then noticed that improvements were located in that easement area, the retaining walls. Um, I then made a review comment citing the code stating that um, I don't know the exact code language, but that, the code section about structures and the limitations of them being present in an easement area.
Okay. So you provided them a review comment. And so how did the applicant respond?
Yeah, so the applicant responded with the driveway relocation easement documentation in a resubmittal indicating that the easement was no longer present in the previously marked area.
Okay. And so when you say driveway relocation documentation, what are you referring to?
Yeah, I'm referring to, my apologies. My apologies, I'm trying to locate the exhibit number. So, oh, I still am looking for the exact exhibit number, but it's the driveway relocation document is referenced on the approved plan site survey
Okay.
as the new location of the ingress egress easement with the recording number starting in 2017.
2017. Okay. So to your recollection, was that a 2017 document that was provided by the applicant?
Yes, it was.
Okay. And I know we saw earlier a 2021 decision by former Superior Court Judge Matt Siegel. Was that something applicant had provided to you?
No.
Okay, thank you. I am going to pull up city exhibit number 7, which is one of the plan submittals. Okay, that has my apologies. This is having a technical difficulty. Okay, here we go. Okay. So Ms. Manahan, are you able to see my screen?
Yes.
Okay, and this is exhibit 7?
Yes.
Okay. I'm sorry to talk over you. I did not mean to. I'm going to scroll down to the final page. I'm going to zoom in a bit here. So, Ms. Manahan, this is not the approved plan set. Is that accurate?
Yes.
Okay, so this shows some structures that aren't in the location that the city has ultimately approved in the building permit. Is that right?
Yes.
Okay. I'm going to use my cursor and cursor over a portion of the retaining wall. I'm going to circle this area here. Are you able to follow my cursor?
Yes.
Okay. Is that part of the retaining wall roughly in the same position that's as on the approved plans?
Yes.
Okay. And then this particular site plan does show the dashed lines that appellant refers to as the middle easement. Is that right?
Yes.
Okay. And so looking at this, would it be your opinion that this portion that I'm circling of the retaining wall would encroach into the appellant middle easement?
Yes.
Okay. Thank you. Ms. Manahan, with the additional information that the city has looked at since receiving the appeal and the testimony this morning, would re-review of this building permit potentially lead to a different result?
Yes.
Okay. And what result would that be?
Yeah, that result may be to remove the retaining walls from the easement area.
Okay. I want to loop back just a little bit just to clear something up in the record. I'm pulling up city exhibit number 18. Ms. Manahan, are you able to see my screen?
Yes.
Okay. Do you recall receiving this email from Doug Scott?
Yes.
Okay. And with respect to this email, did it relate to what we've been referring to as the middle easement or a different easement?
This was regarding the north 5-foot utility easement and it was referring to the north 5-foot utility easement.
Okay, but not the middle easement?
Correct.
Okay, thank you.
Apologies for my interruption. What exhibit number is this?
Sure, this is exhibit 18.
Gotcha. Thank you.
Yes. I'm looking through my notes here, Ms. Manhan, to make sure I haven't missed anything. Just a few additional questions. Ms. Manahan, we heard discussion this morning about a survey, and I just wanted to ask, did the city approve any surveys? Is that what the city does as far as the building permit?
Not necessarily approve the survey, we're approving the proposed improvements in the plan set.
Okay, okay. And does the city have to, or I'm sorry, does the city always require a survey for a building permit?
Yeah. Surveys aren't an outright requirement for building permits, but the city may require them.
Okay, okay. So, when it comes to filing the permit, is an updated survey a requirement, or can the city rely on the inspection that you referenced earlier in your testimony?
Yeah. The city can require an updated survey to show like the new as-built conditions.
Okay.
Mhm.
Okay. Okay, those are all the questions I have for you, Ms. Manahan. Thank you.
Thank you.
Okay, Mr. Weiss, any cross?
Well, I think it would be the appellant's turn probably first.
Well, I have the party in the most adversarial position to the last cross is the order that I do. So
Okay, sounds good. Ms. Manhan, thanks for your work on this project and working with my clients. Um, I just want to be pretty clear, in part because my clients here, as are the contractors involved. Um, I understand that in order to be compliant with the city's requirements, a gazebo needs to be moved some distance. I guess it would be kind of to the northeast. Um, how far does it need to be moved to be compliant, that is?
Yeah, it needs to be built to the approved plan set. So yeah.
Okay, and I'm not trying to grill you on this, but do you know what that
Yeah.
distance is?
I do not know the distance.
Okay.
Mhm.
In terms, does the city code define what a retaining wall is?
The city code does have retaining wall in our definition section.
And are you able to tell me what a retaining wall is defined as?
Oh,
Mr. Weiss, would it perhaps be helpful if I pull up the city code and you guys can look at it together?
Yeah, sure thing.
Okay.
yeah.
While she's doing that, Ms. Manhan, let me just, is there, does the city code differentiate between landscaping and hardscaping?
We have like a definition of hardscape. Mhm.
So, Eileen, I assume you're screen sharing right now?
Yes.
Okay. Sorry, it's so small on my screen. So I'll just read it into the record and for the benefit of the hearing examiner and the parties. It just says, I guess this is what 19.16.010 definitions: retaining walls / rockeries, a wall of masonry, wood, rock, metal, or other similar materials or combination of similar materials that bears against earth or other fill surface for purpose of resisting lateral or other forces in contact with the wall and or the prevention of erosion. Okay. Ms. Mann, is there a height limitation on this or not?
Yeah, I think as you've just read, there's no mention of height in our definition.
Is a permit required to build let's just say, a retaining wall of 2 feet or less?
If it's located within GLOT in any critical areas, a building permit would be required, yes.
I see. And so just to be clear, the area where these two homes are located is considered to be in a critical area?
Yes, that's correct.
And is that because of the slope?
Yeah, that's due to there's geologically hazardous areas located. Um, looks like potential slide erosion and seismic.
I see. The email that came from my colleague Doug Scott to you earlier last year, did you respond to that email?
I I don't want to speak incorrectly, so I'm going to say I don't know.
Fair enough. Is it your understanding that as a code compliance officer that structures can be placed in an easement area so long as there's agreement by the landowners?
Sort of. If we want, we can look at the easement code language. For ingress egress easements, no encroachments are allowed.
Right. And for utility easements? And
So
I'd be happy to read it to you. In fact, I could even screen share if that's helpful.
yeah, I just put it up as well. But yes, yeah.
Let's make sure we're looking at the same thing. I think it is, oh gosh, you probably know better than I do, but it's 19. Oh, I have to scroll all the way up to see what it's, sorry, it's 1902020H, I believe.
Yes.
Sorry, I'm scrolling back down to it. When I expanded my screen, it lost it. Technology glitches here. Where's H? Forgive me.
Mhm.
Sorry, it was 020.
Oh yeah, down to H.
Let's see. So here, I'll do a screen share.
Mhm.
So I'm going to just highlight it for ease of sharing. It says, no structure shall be constructed on or over any easement for water, sewer, storm drainage, utilities, trail, or other public purpose unless it is permitted within the language of the easement or is mutually agreed in writing between the grantee and the grantor of the easement. Do you see that, Ms. Manahan?
Yes.
I'm going to stop the screen share. Based on that, do you know whether there was an agreed writing that between the parties here, that is the appellant and the applicant, that structures could be placed in utility easement areas?
Yeah, so when I was doing the review process with the applicant, I requested them show compliance with that code section you just stated. No agreement was provided to me during the review process.
Okay. You received the email that was shared with you by Attorney Doug Scott, though, and he provided you with the declarations.
With, I'm sorry, can you reshare that and
Yeah, I'd be happy
clarify
to.
what you're speaking to?
Um, what exhibit number was that?
So,
Ms. Kiefer shared it, but
yeah.
For the interest of time,
okay,
it's Exhibit 18.
thank you. Okay.
I see, yes, he shared the declaration materials.
Gotcha. So I'm sharing the screen sharing with the parties here. And this is from Exhibit 18, which Mr. Scott had emailed to you.
Mhm.
Um, do you see it says, I'm going to read section D, and it reads, quote, the owner of the upland parcel shall have exclusive control over the landscaping of the easements described under subparagraphs A, B, and C, provided that no owner of the upland parcel shall erect, construct, plant, or maintain any fence, rockery, shrubbery, or similar device for the purpose of denying access to or physically enclosing any such easement herein reserved without first obtaining written consent of the owner of the waterfront parcel. So I was reading that into the record, but Ms. Manan, do you understand that this controls between these two parcels of property in terms of what can be done?
Yes.
Yeah. Do you understand that it has the caveat of for purposes of denying access or physically enclosing? That's a terrible question. So I'll retract it because I know you're not necessarily in a position to answer that.
Yeah.
Um, Miss Manhan,
Mhm.
is the city taking a position on whether or not a utility easement exists in the middle of my client's property?
Can you repeat the question?
Sure. Well, let me ask you this. Do you, as a representative of the city, do
Mhm.
you know whether there was or is currently a utility easement through the middle of my client's property?
Yeah, I think as previously stated, based on the record, we do think there is an easement there.
What is that belief based upon?
Yeah, that belief was based upon the new information provided through this appeal process.
Is it My inference is, and I want you to correct me if I'm wrong, but that's based upon the Superior Court order that was provided to you. Is that correct?
That was seen as very relevant information to the city while reviewing whether or not the easement was present. Correct.
Okay. Is there any other legal documents or title documents or ownership documents that the city believes indicate that there's a utility easement through the middle of my client's property?
And besides I mean, as I stated, like in the initial review, I identified the easement being there through like our GIS mapping, and I've seen it, on various documents throughout the years, but nothing beyond what we've discussed so far today. Thank you.
Okay. Thank you, Ms. Manahan. I don't have any other questions.
Okay.
Okay, Mr. Yip, any questions?
No, thank you very much for your testimony.
Okay, and Ms. Kiefer, any redirect?
None at all. Thank you. Thank you, Ms. Manahan.
Yeah, thanks, Ms. Manahan. Thank you for your time today.
Thank you.
All right, and Ms. Kiefer, anyone else from the city? I think that was the only person on your witness list.
You are correct. That
Okay.
concludes the city's case in chief.
All right, perfect. I guess now we'll move on to the applicant, Mr. Weiss.
Okay.
Maybe we take a quick 5-minute break.
Yeah, I mean, we're going to be taking our lunch break in
I
about
see.
20, but yeah.
Oh, okay.
Is that okay then, Mr. Yip, or did you need?
Yeah.
Okay, all right, yeah. Let's charge. We'll take our lunch break at noon then instead of 12:15.
Okay. What I'd like to do, just so that they don't have to remain on this phone call, is see if I can quickly get in the testimony of Gary Moe and Christopher Gregerson, who have kindly joined us. So, and then I'll have Ms. Liu testify after the lunch break. That
Okay.
makes sense.
All right, we're starting off with Mr. Moe then.
Okay.
All right, Mr. Moe, let me swear you in. Just raise your right hand. Do you swear affirm to tell the truth, nothing but the truth in this proceeding?
Yes.
Great, thank you, sir. Welcome to the
Thank you.
hearing. And Mr. Weiss, go ahead.
Sure. Mr. Moe, just please, why don't you just introduce yourself?
Yeah, I'm an architectural designer working with my clients to do design and permit applications for the site improvement and the new building and remodeling.
Are you a general architect, or do you specialize in landscaping and outdoor work?
I do most architectural design. Yeah, I do some construction, but for this project, Chris, he's the contractor in charge of the construction.
Can you tell me how you came to be working with Tammy and Can on their project?
Yeah, it was about a year ago, and I got a phone call from Tammy, called me about he got the notice from the city about the unpermitted landscaping work in her front yard, and then I met Chris, and we reviewed the site, and we collect all information from the survey, structural engineer, geotech engineer, contractors, and documented what they have done on site. And we start to do the design and do the permit application, followed by the city's instruction and requirements.
Now, when you came to visit Tammy and Ken's house for the first time, most of the work had already been completed at that time. Is that correct?
Correct. Yes.
Uh, do you know what other professionals Tammy and Ken had hired before you to do the work?
Uh, I'm not sure because I don't know the timeline. Maybe they hired the geotech or surveyor. I know they hired surveyor before. And then Chris, he contacted the landscape architects, geotech, structural engineer. So at the same time, I don't know what's the timeline before or after. I'm not sure.
Okay. What was your role in trying to get their landscaping project approved by the city? What did you do?
Yeah, I do. I I do the site plan. I'm using the background from engineer and the surveyor and put them together and fill out all the forms, do the calculations for the site area requirements. Yeah. So, and then apply the permit.
So are you the person who did the permit applications with the city of Mercer Island?
Yes, correct.
Uh, were you doing those essentially as an agent or representative of Tammy and Can?
Yes, correct.
Did you also have any telephone conversations with Ms. Manahan?
Yes, but not too many times. I think couple of times. I yeah.
What was your goal in doing this work for Tammy and Can?
My goal is as a drafter and also architectural services and application services.
Were you trying to comply with all the city codes?
Yes, just follow all the instruction from Grace.
Uh, have you done, since you did all the application work, have you done uh, made any changes or actually done any additional work since the time you began helping them with the application process?
I think so. Yes, we do the revision and correction back and forth. I think at least 5 or 6 times.
I see. So you have submitted revised plans to the city for approval?
Yeah, it's a long, very long
I
period
see.
of time to do that. Yes.
Uh, did you have any, through your process of design and drafting these site plans and the various renditions of them, did you have any notice that there was a utility easement through the middle of the project?
Well, at the beginning, I don't know. At the I just read. I'm pretty focused on the setback and the easement on the north and the south. I'm not sure we have a middle easement at that time until later Grace told me we have to clarify there's an easement in the old driveway. Yeah.
I see. Okay, Gary, I don't have any other questions for you. Other council may have questions for you.
Okay.
All right.
Thank you.
Mr. Yip, any questions?
No questions. Thank
All
you.
right, Ms. Kiefer.
None for me. Thank
All
you.
right. Okay, Mr. Mo, you had it easy today. Thanks for your help. Appreciate
Yeah.
it.
Thank you. Yeah.
Yeah, have a great weekend. Okay, Mr. Weiss, you had another witness you wanted to get through real quick?
Yes, Christopher Gregerson, who's on this Zoom call as
Okay,
well.
Mr. Kregerson, we don't see you quite yet. You're still black. You have to turn on your video if you can.
I was
He
I was having an issue
There
with
you
my computer, so I still like the computer for the documents, but I'm talking through my phone, if that makes
Oh,
sense.
okay. We see you. Yeah, okay, great. All right. Well, let me swear you in. Just raise your right hand. Do you swear affirm to tell the truth, nothing but the truth in this proceeding?
Yes, I do.
Okay, great. Thanks, Mr. Gregerson. Welcome to the hearing, and go ahead, Mr. Weiss.
Okay. Mr. Grierson, thanks for being here. Uh, I'm going to ask you similar questions that I asked Gary. So I'll start with just introduce yourself briefly and tell me what you do for a living.
Christopher Gregerson with Gregerson Custom Homes. We've built a lot of homes along Mercer Island, Bellevue. A lot of experience with steep slope, retaining walls. I built the house next to Ken and Tammy. Became friends with them. I've done some work on their home for them. Yeah.
Okay. Uh, how did, well, actually, what work have you done for Ken and Tammy?
Um, they had some issues with some water damage around their house. Some waterproofing issues from the builder that built their house that I came and corrected and fixed for them.
Got it. In terms of this front yard landscaping project, did you do any of the construction work of this?
No.
Do you know when that was done and who did it?
Um, I I can't recall his name. I've met him a couple times. I could look at the stop work order of when that was actually done. It was March 3rd, 2023, when it was roughly somewhat completed in the process, from what I recall. That's when I was first notified.
Okay. How come, or why were you notified of issues with their landscape project in the front yard?
Um, the landscaper was there, building everything, and a stop work order was put up. So Tammy called me just because, she knows me, trusts me, and so she called me. I came out, looked at it, called Dave Henderson to kind of get a grasp of how this process would move forward.
Who's Dave Henderson?
He was a code compliance person at the city of Mercer Island. I've worked with him quite a bit just on other projects on Mercer Island. Sometimes he would fill in as a building inspector. So I was familiar with him.
Okay. So he had a similar role as Miss Manahan, it sounds like.
Yes. Yes.
Got it. So this work stop order, that was something that came from the city of Mercer Island, is that correct?
Yeah, like a red sticker on a stake that just, said, hey, you don't have a permit for this. You got to get proper approval. So hold off on the project until you can get the proper, permit.
Did uh, did you get the impression, or did you think that the prior contractor or Tammy and Ken were trying to be elusive or sneak this project through?
No, no, I don't think that a lot of times you will see homeowners working with a landscaper and they're not as aware as a general contractor of the requirements, in the different cities to get a permit.
Okay. So in other words, they just didn't know a permit was required.
That's what I believe.
Um, After there was a stop work order and you became involved helping Ken and Tammy and working with Gary, what role did you have?
I was really just trying to facilitate with my contacts, who best could help us get all the proper documentation and, get something designed to follow all the codes and ordinances that we need. So when I originally talked to Dave Henderson, when they first put the stop work order, his first guideline for us was, what we need from you is to come up with a plan for this project, almost looking at it like this, none of this work has been taken place yet. So everything we've come to draw up is showing, not what's there currently. It's what the final product will be after we follow all the proper codes and regulations. So
I see. So it's not drawings of the as-built construction.
yeah, we got
Sure.
as-built drawings, obviously, to help with the design and see what's there, topography, elevation, stuff like that. But yes, the end goal was always follow all the proper codes and submit something that would, get approval. So
Yeah, I assume that our hearing examiner knows this, but I mean, is it unusual for people to apply for permits after the fact, after work's been done?
no, that's, you hear of that often.
Um, Now, did you do any digging, no pun intended, to determine whether there were easements?
I did go on the GIS, website, and there's a lot of documents on there. I tried to go through them all and see what was relevant as far as you know, just trying to wrap my head around the general topography and the previous permits and what was said. So I did look through some of that, yes.
Did you come to the conclusion there was a utility easement through the middle of Ken and Tammy's garden area?
I did not. I was of the assumption that that was an old driveway easement that got shifted and into the new driveway location.
And when you were on site, I mean, you could see that the driveway was in a completely different spot, correct?
Yeah.
Uh, did you have any notice that there was a water line going through the garden area?
Well, I know that Ken and Tammy have a water vault up there, partly for their fire sprinkler setup. But yes, I wasn't aware of the neighbor's water line coming through that location.
Okay, I don't think I have any other questions for you, counsel, for the other parties may or Mr. Olbricht.
Mr. Yip, did you have any questions?
No, I have no questions for him.
All right. And Ms. Kiefer?
No, thank
Okay.
you.
We'll see you all then at 1 o'clock.
Thank you.
Thank you for your testimony, sir. All right.
Okay, thank you.
February 27th, 2026 at 1 o'clock p.m. We're in the Lynn versus Mercer Island case. We still have Mr. Wace presenting his witnesses. So I believe we're on to the next one. Mr. Wace, who did you want to call? Oh, Mr. Wace, you're muted. There you go. Still muted, yeah.
Okay, there we go.
Oh, there you go. Now we got you. Good.
There seems to be a little lag in my Zoom program. Must have had too much carbs at lunch.
Yeah.
In any event, so we are going to now call our client, Miss Tammy Liu, as our witness.
Okay, great. All right, Ms. Liu, welcome to the hearing. Let me swear you in. Just raise your right hand. Do you swear affirm to tell the truth, nothing but the truth in this proceeding?
Yes. Yes.
Okay, great. All right, go ahead, Mr. Weiss.
Sounds good. Miss Liu, why don't you just introduce yourself to our hearing examiner?
Okay. Hi. Hello, everyone. This is Tammy Liu. My husband Ken and I are the owner of a property of 8636 North Mercer Way. We purchased the property in early of 2010. At that time, the house was very old. We later demolished it and built a new home. So part of the property, as we discussed today, has a very steep slope. So managing the drainage, soil stability, and the safety has always been a major concern for us.
Let me back up a little bit. So when you purchased the home on Mercer Island, was there already a home there?
It's very old home. That's a
Did
beautiful.
you ever live in that home, or was it immediately demolished?
No, we never lived in that home.
So when you guys bought the property, you and Ken, did you contract to have contractors and architects and so forth build and design and build a new home?
Yes, that's
Okay.
In 2011.
Okay. Can you explain that process that you went through in terms of like hiring contractors and building a new home and all that?
Yeah, in 2011, we went through a full city permit process to contract our new home. I think the architect is Chandler Stever. We hired a licensed professional. We obtained all required permit, and the plans were reviewed and approved by the city, and all inspections were completed and approved by the city.
Okay. Did you have somebody helping you and your husband get the permits into the city for the building and landscaping and all that work?
Yeah, I believe that Chandler Stever, our architect.
I see. Um, did early on, like when you in that first year or two, when you purchased the property and were building the home, did you and your husband have an understanding of what easements existed on the property back then?
There was an old driveway that we revised it to the new location.
So when you purchased the driveway, or I'm sorry, when you purchased the home, where was the driveway at that time?
That in the part of my garden. So right now, in the location we are talking about.
Okay. And so when was the driveway physically moved from kind of the middle part of your property or where the garden is now into the southern edge of the property?
That's the part of the process for our build our new home. Yeah, in 2011, I think. Yeah, the access and the utility easement was formally revised and approved by the city.
Now, back in 2011, there was a downhill neighbor or waterfront neighbor who owned that property. Who was that back then?
That's Mr. Delkin and Mrs. Patricia King.
Okay. So when you bought the property, the Keens lived in the house that Melina Lynn now owns?
Yes, yeah, we enter into the agreement with Mr. Delkin and Mrs. Patricia King. Yeah,
What type of agreement did you enter into?
that's the relocated easement, driving easement to
I
the
see.
new location. Yeah.
I want you to pause for a minute because I want to just make reference to I'm sorry, I keep calling you arbitrator, the hearing examiner. The exhibit is 2006. It's applicant's exhibit 2006, which is the 2011 relocation agreement. Um, Now, Miss Liu, after when was your home completed? All the construction, including the rerouting of the driveway?
I think in 2000, early of 2013.
Okay. So it took more than a year or two to complete?
Yeah, about 2 years, a little bit more than 2 years, I think, since the application submit. Yeah.
Um, were you and Can living in the area at the time?
No, no, we live in our previous house.
Okay. Where was that?
That's in the Sammamish.
I see. When the driveway was moved from its location that it existed in when you purchased the house to its present location, approximately how far was it moved? And you can just give an estimate.
Yeah, I just can go with the estimate. Probably approximately 30 to 40 feet to the south, closer to the southern property boundary.
I see.
Yeah, that's a move from the middle of the property. Yeah.
Was the old driveway paved or asphalted, or was it gravel?
I forgot. Probably paved like asphalt. I cannot remember, since that was really old and that's everything's demolished.
I understand.
Yeah. Mm-hmm.
When the new driveway was asphalted in its
Yes.
present location, did you and your husband pay for the asphalt work of the new driveway?
Yes.
Okay. And that driveway, it serves the waterfront parcel as well, is that right?
Yeah, it's a driving easement. Yes.
Okay. And in the prior owners, Dell and Patricia Keene, they would drive down that driveway through your property to access the waterfront parcel.
Yes.
Okay. Um, were you ever aware that there was a water line servicing the Keene property that went through the garden area under the old driveway location?
No.
When did you first learn uh, that there was in fact a water line that went under the location of the old driveway?
That's in 2021.
Okay.
Before that, we have no knowledge of where the the water utility were located. That's in 2021 litigation was the first time we have heard that claim.
And so how did you find out in 2021 that there was actually a water line under the old driveway location?
That's the Melinda Lin's claim. That's from Melinda Lin's claim.
Okay, so you understand she had hired somebody to come and locate the water line?
Yes.
Uh, are you aware whether there are other utilities that run under the or near the current driveway, such as
No.
electrical or cable or phone lines?
No, I believe in the document, all the utility should run the southern property boundary, that southern easement. I cannot
Dude,
recall there's a really old document from a Puget Sound Energy, something like that.
got it. As far as you know, though, the only utility that runs under the middle part of your property where the old driveway was is just the water line that goes to Ms. Lynn's home.
Yes.
Tell me about, or actually really tell Mr. Olbrechts, our hearing examiner, about why you wanted to do a garden and make improvements to the area upslope of your home near West Mercer Way. Or
Yeah, since this area is like just as I stated at the beginning, this area has a really steep slope, and that's the cost dangerous to our house. And so if we keep as the previous condition, we worry about the safety. So we have a slow storm water runoff, and that's made our house is very dangerous. So that's why we want um, to make that area safe. That's our purpose to do this project.
Did so before you did the landscaping and hardscaping work, what would happen if there was like a heavy rainstorm that we get, of course, here a lot in the Pacific Northwest?
Yeah, that's we have since in that area there are several really tall trees, and there was one tree used to lean to our house. My guest house, and I think we got the city permitted to remove it. So and also the soil erosion, that's a big problem. And slow water runoff. That's another big problem. So yeah, that's why we want to, to change that condition.
When it would rain heavily, would dirt or like mulch or beauty bark, as it's called, would that like run onto the paved
Yeah,
portions or the driveway?
yes, to our like the pathway. Yeah. And
Would you
also
then have to like
tree.
sweep it or shovel it back up into the garden area?
Yes, yeah, we ask our landscape helper, to come to clean that area all the time, especially after heavy rain.
I see. So when did you start the project that's now at issue in this hearing? When did you begin the work?
Yeah, we began the work in the late of 2022. So that's we wanted to stabilize the slope and improve the safety. At that time, our landscape contractor, whose name is Mark Costa, who is our landscaper for more than 10 years, initially advised us and without permit to do this project. That's based on his experience to work in the Belleville and other city. And so when my project was nearly completed, and Melina complained to the city, so we immediately stopped and hired a licensed professionals, Mr. Gary Mark and Mr. Chris Gregson, to prepare proper design, engineering, and permit. So our goal has always been full compliance with the city code.
Did before the city had you stop the project, did you know if any permits were required?
No.
Did your landscape contractor who did the work initially, did he have at least professional looking architectural drawings of what was going to be done?
I think since it just sounds like he consulting his architect design or some landscape design. Since I, give him authorization to do this project, so I will let him handle everything.
I see. Was it a situation where he provided you with a bid or cost estimate to complete the project, and then you agreed to it and he got to work?
Yeah, since he works for me more than 10 years, I trust him. At that time, I did not bid with the other contractor.
I see. Did this contractor, I heard his first name was Mark. I didn't fully understand the last name. What is his last name?
I think Acosta.
Acosta. Got it.
Mm-hmm.
Did Mr. Acosta also build the pergola?
Yes.
Did he also assemble the greenhouse that's next to the pergola?
No, I hired a professional.
Okay.
Yeah, that's especially for this kind of greenhouse. I mean, yeah.
The greenhouse, it's mostly glass panels held together with a frame. Is that right?
Yes. This greenhouse I purchased from Costco. So Costco recommended me the professional assembler.
Can the greenhouse be, I understand it can be moved, right? But it has to be disassembled because of all the glass panels.
I don't know.
Okay, that's fair. So what what communications did you have with Gary Moe and Chris Gregerson to help the city get approval on the project?
Oh, that's a lot.
If you
think
could summarize.
yes, that's since we hire the professionals. I will let the Mr. Gregson to cooperate with all the professional we need. So yeah, so we we keep send the email and share the information and know the process and the step that the city request. Yeah, I know there's Mr. Mark sent several times based on city to the application to the city based on the city request. And during the process, we hired all the professionals that city, yeah, based on the city request.
After I just want to kind of go through the history of ownership. After Dell and Patricia Keene sold their property, there was a gentleman named Mr. Ma who owned the property for a period of time. Is that right?
That's correct.
And then in 2017, Mr. Ma sold the waterfront parcel to Melina Lin. Is that correct?
Yeah. Yes.
Did you and your husband Can have any issues working with the first property owner, the Keens, in terms of easement issues?
No.
Did you and Can have any issues working with Mr. Ma in terms of easements?
No.
Did the disputes regarding the easements and use of the property only arise after Miss Lin purchased the property in 2017?
Say that again. I'm sorry.
Did the disputes only start to happen after Miss Lin bought the property?
That's correct.
Sorry, I'm just looking at my notes here. How do you, over the last 5 or so years, you've communicated with Miss Lin quite a bit, but by email, is that correct?
You mean for what purpose?
Well, with easement issues and access issues, have you communicated with Miss Lin by email?
Probably at the beginning we have an email communication, but most of a communication we authorized Mr. Douglas Scott to communicate with Miss Lee.
I see. Recently, that is just this year, Miss Lin and you were emailing about having a utility locate company come up to investigate a leak of the water line. Do you recall that?
Yes.
Can you please tell our hearing examiner, I don't expect you to tell exactly every word that was said, but just tell them how that communication went and what the point was.
Yeah, I think in the middle of December last year, Miss Lin sent an email to my husband and forwarded the city's email for the water pipe leaking issue. Since that time is our holiday season, and so we've arranged our holiday schedule in advance a long time ago. So I replied her email, and I said I give her my available timeline, for the inspection come. And at the first couple of email, she gave me the schedule is based on her availability. So that's did not work for me. So I give her the timeline, not the specific date, like afternoon from 1 to 4 or something like that. And but finally, I cooperate and allow the inspection to come. The first inspection was on January 14th of 2026. And the result from the CNI and that shows no leak was found on my property. And the technician told me clearly the leaking is in Melina's property. So the inspection was inconclusive.
Now I understand that Melina Lynn emailed you again and wanted another inspection, which took place just last week. Is that right?
Yes, yes. I think that as she mentioned, that happened on last Thursday, February 18th. Yep, I still allowed it. Yep.
Did you in your communications put any limitations on that inspection?
Yes, yes.
What were those limitations?
Yes, I said that's the only purpose for the leak detection, that it would not be used in the administrative hearing. However, the inspection did not search for leak. It was used to locate the water line and document my garden construction. And Ms. Lin entered my property, filming and taking photographs without my permission, which I had clearly prohibited in my email several times. So the leak inspection was actually a pretext to collect the evidence for this hearing. And the test result still no leak found in my property.
I want to ask you about your knowledge of easements. Do you know where the utility easements are on your property that service Miss Lynn's property?
No.
Okay. Do you believe that the legal documents that are recorded, with the county and the title company, those are the best to demonstrate where the easements are?
Yes, I believe so.
To your knowledge, has there ever been a utility easement that exists through your garden area?
No.
Do you believe that let me ask you this. When you had the contractor, Mark Acosta, do the work in your garden area and build the different height retaining walls, did you build any of the retaining walls for the purpose of obstructing Miss Lynn's access to the water pipe?
No. Since I also don't believe this area is a utility easement.
Sure.
And my purpose for this, as I said, a purpose for this project to prevent soil erosion and slow stormwater runoff. That's to protect my home and protect the neighboring property downhill. That's my purpose. It's a safety, major purpose.
Despite the existence of what I would call a very, very short retaining wall, if Miss Lynn needed to access that for actually servicing her water line in the future, would you allow that?
No, since this is not easement area, the utility easement area, I don't think she need to walk into my property. If there's some technical issue, we need a professional to fix anything. I think that they have so many methods to detect the leaking and repair the problem, use the new technique just under the ground.
So you understand that companies could use trenchless technologies to repair or replace the water line, even in its current location?
Yes, if the water line is still in this position, but we have a question how we will use the technique to do that. I need to know the detail about the method. how to do that. It's,
Let me ask you this. If Miss Lin were to redirect or reinstall her fresh water line 30 feet to the south, such that it was adjacent to or under the existing driveway, would you allow that?
I will. That's based on the 2011 agreement with Mr. Delkin and Mrs. Patricia King. Yeah, and also that permit approved by the city. We will allow.
You know, Miss Liu, I don't think I have any other questions for you. I think we covered what we need to. Mr. Yip may ask you questions, and our hearing examiner may ask you questions, and Ms. Kiefer may ask you questions.
Okay, Mr. Yip.
Yes, I just have a few questions to follow up. Okay, so I will just bring up city exhibit number 9, and I will share my screen. Just a minute. Share screen. Okay, Ms. Liu, do you recognize this drawing?
Yes.
Okay, and can you describe what this drawing is?
That's the application to the city to get the permit for my project.
Okay, and in this diagram, would you agree that some of the gazebo and the greenhouse seem to be in the front yard setback?
Now I will follow the city's request.
I'm sorry, can you repeat that? I don't quite follow.
I will follow the city's request.
And what is the city's request?
It's based on the city's, it's on the approved permit.
Okay, so but that's not what I'm asking. I'm asking just according to this diagram, which I understand you submitted, does it show part of the buildings being in the setback?
Can you indicate the point and the area?
Yeah, so just this around this area
I
right
think
here.
if you ask the question, I think this should be answered by Mr. Mark. I'm the technical person. I'm not a professional person. I don't know the detail should meet the city's code or something like that.
Okay, and then for this this area here to the northwest, I suppose. My understanding that what this shows here and within 5 feet of that boundary is a retaining wall.
Yes, I think so.
Okay, is the retaining wall there right now?
Yes.
Okay, now I'm just going to turn to exhibit number 23. I would represent this as the approved plans, just so that everybody would know. Here's a review for code compliance. This is exhibit 23. Do you see this exhibit?
Let me see. Yes.
Okay, so would it be correct to say that the retaining wall that used to be in that north 5 foot area has this it shows that it will be removed from that?
Yes, I saw that's from the drawing. Yes.
Okay, can you describe how you plan to remove the retaining wall from the area?
No, I'm not the professional. I don't know how to do that.
Okay, but if this, but would it be fair to say that whatever the city requires, you will follow?
Yes, we will follow the city's request.
Okay. And then just one more thing I want to clarify. Were you involved in the prior 2021 litigation with Melina Lin?
I think so.
Okay. Have you previously, prior to this appeal, have you seen the orders from that lawsuit?
Yes.
Okay. Um, um, okay, just a couple more questions. Can you describe what your occupation is?
By occupation?
Yeah, what's your job? What's your employment?
Yeah, I'm a self-employee.
Okay, but in what field?
We do the import and export.
Okay, are you an engineer?
No, I'm not.
Okay, and are you a surveyor?
No, I'm not.
Okay, and do you have any experience in terms of like locating or maintaining water lines?
No.
Okay, I have no further questions.
All right, Ms. Seifert or Kiefer, sorry.
No questions for me. Thanks, Miss Liu.
Mr. Wace, any redirect?
Yes. Just briefly, Ms. Liu, Mr. Yip, he showed you images, plans showing the retaining wall that's along the north boundary that goes within the 5-foot easement area. Do you recall him asking about that?
Yes.
Uh, were those retaining walls built for the purpose of limiting anybody's access to a utility easement?
No. This the purpose only for the safety because that has a very steep slope in that area. It's a cost dangerous, cost problem all the time. So I think that if we won't change the condition in that area, that will cause a big issue not only to my house and also to my neighbor's property.
Okay. Do you know if, in fact, the retaining walls that are presently constructed within the 5-foot wide easement area to the north, do they actually go over any known utilities?
No, from my knowledge, there's no any utility on that side.
So to the best of your knowledge, the easement area that's designated on the north boundary of your property doesn't actually have any utilities going through it. Is that right?
That's right. Yeah.
And it's your understanding that the only utilities that go across your property are in the south boundary line, as well as the one singular water line through the garden area. Is that right?
That's correct.
Yeah. Nothing further.
All right. Thank you, Ms. Liu, for your testimony. Thank you for
Thank you.
sharing your information today. All right, Mr. Weiss, I guess you have one final witness, right?
I think he was listed. I think it's a gentleman from the title company, and I do not intend on calling him
Okay, so you're finished?
unless he's on this call, but I don't see him.
Okay, all right. Well, as I said, I think that after applicant, is general public testimony. So at this point, then I'll just ask if anyone from the public wants to say anything. And Ms. Estrada, is there anybody from the public that's participating virtually today? Can you tell?
We do have, excuse me, one person, a Meg Lloyd.
Oh, right. And Ms.
Yeah.
Lloyd, if you want to say anything, just click on your raise hand button and then we'll call on you and make sure you can comment. All right. Not seeing that you're taking us up on that. That's just fine. All right. We'll move on then to the rebuttal portion of the hearing at this point. And now we first go back to Mr. Yip as appellant. And after that, the city, and then finally the applicant.
Okay, for the closing?
Yeah, this is rebuttal. At this point, we'll have a separate closing.
Oh, for the rebuttal.
Yeah.
We don't have any rebuttal case.
Okay. What about the city? Any rebuttal evidence?
No rebuttal from us either.
Okay, and finally, Mr. Weiss, applicant? I guess not.
Yeah, I just concluded, so.
Yeah. So, okay, and again, if anyone out there from the public, you can click on your virtual hand. All right, so we'll move on to closing statements. Then applicant goes first, Mr. Yip, then the city, and then the appellant finally, or excuse me, Mr. Weiss, sorry. Yeah, you get to go first on closing.
Just to be clear, because I think you might have misspoke there, but the appellant goes first. Is that correct?
Well, according to the, yeah, no, I know it's weird. According to the hearing exam rules, it's the applicant goes first.
Right.
Yeah. Yeah. Appellant, since they have the burden of proof, gets to go last.
I see.
Yeah.
Well, in that case, I know there's not per se time limitations on this, but I would, since I get to go first, that at least in Superior Court or District Court matters, means I also get to go last. So what I'd like to do is just reserve a few minutes for the end. And
Okay.
so
It's like I said, these are the hearings. I didn't put these rules together, but you know, and like I said, since the appellant has the burden of proof, they really get to go last. It's just not a, you know, a duel. You don't get two shots at doing closing. But I certainly, I'm very flexible on that. If you know, you see a need to say something after the other parties have completed their comments, that's fine. I mean, as long as the appellant goes last, I'll always give them that chance.
I understand.
Yeah.
Okay, well,
Yeah, we want to stick to the hearing examiner rules, and if we are going to go in last, we don't agree to let them reserve any time.
Yeah. Well, and like I said, I mean, if Mr. Weiss, after you're done with your comments, Mr. Yip wants to add, so I'll probably let him, but then I'll let you do a server rebuttal, essentially. You know, you'll still.
I understand, and I appreciate that.
Yeah. Okay. Yeah. Sure. Go ahead.
So let me see here. Don't have a ton of time to prepare my thoughts here, but I got them. So let me start with this comment. The appellant, Ms. Lynn, and her attorney have, throughout this hearing today and in their briefing, referred to a middle easement. That's a misnomer. There is no middle easement. Mr. Yip and Ms. Lynn keep saying there's a middle easement, but in fact, that's not supported by any legal documents. So it is my client's position and my position that no middle easement exists. It's calling a space on a map an easement over and over and over doesn't make it an easement. The only thing that does, particularly with a short plat, is the short plat document itself. And it has to be in writing to comply with the statute of frauds. It has to be signed off by the property owners, and it has to be approved by the municipal agency, whether that's a city, county, etc. And in this case, there are utility easements that exist. There is an access easement that exists, but none of those exist in the garden area that's at issue here. It's beyond dispute that there is, in fact, a water line that goes through the garden area. But the water line doesn't mean that there is a utility easement by virtue of its existence. They're not claiming prescriptive easement or anything of the sort. They're just saying that there's an easement here. In fact, the documents don't support that. Nor does the history of the documents on the title of this property. I've got a little slideshow presentation here, so I'm going to try and do a screen share. I'll make it quick. Share. So that's just my cover slide there. Are you able to see this?
Yes.
Okay. So first and foremost, oh gosh, these sharing buttons are in the way. Okay, now I can move them. First and foremost, so what created these two parcels of property from one property was the 1978 short plat, which is recorded there under number 78-121-80972. This is the document that creates these two properties from one. And so this is what's controlling first and foremost, and the first thing you should look at. I trust it because you do these hearings and you understand the law. You've used to looking at some short plats and other easement documents. I want to direct your attention primarily at the documents that control the property in this case. So the 78 short plat, which is exhibit number 2001, and I think the city also included as one of their exhibits. so it's in the record twice. But the short plat creates parcel A, which is my client's property. Ms. Lynn's property is parcel B. And it says, which I've highlighted here, subject to an easement for driveway and utilities across the southeasterly 10 feet in width. So the critical thing here is the short plat creates an easement for driveway and utilities. So it's conjunctive. It's both things across the southeasterly 10 feet. And so when you go down and then look at the short plat map that was associated with the short plat. So again, 1978, same recording number. It shows a singular access and utilities easement along the southeasterly border. So this is a document I asked Ms. Lynn about in her testimony. This is the short plat map. It's poor quality, unfortunately, but I think we can see that on the south here where my cursor is, where I've highlighted says drive and utility easement. And actually here, I don't know if you can still see my cursor, but the word new is there. So it says, the significance is this. In 1978, this parcel was divided and they created a new drive and utility easement. However, what previously existed was an existing drive. And that's what represented with the dashed yellow, or sorry, the dashed lines and the words existing drive. So the significance is that short plat both describes a singular access and utilities easement, and it shows a singular access and utility easement. So that's what exists, like, period. And that easement exists in the, according to the description, in the southeasterly 10 feet in width. So what's also important in interpreting these documents and determining where the easements is are the declarations. Now, the declarations were recorded in 1981, but they're actually signed in December of 1979 by the then property owners of parcels A and B. And so the declarations, and by the way, these are exhibits 45 of the cities in 2004 for the applicants. But so the declarations expressly define 3 easement areas, 2 of which are utilities and 1 is the driveway. So the declarations, and this is a little bit inconsistent with the short plat, which is part of the confusion here. So the declarations describe the vehicle access as vehicular, pedestrian, and other ingress and egress by the owners of the waterfront parcel, their guests and invitees over a strip of land lying 6 feet on each side of a line denominated the driveway center line on the attached Exhibit A. So, in other words, there's a 12-foot wide driveway that provides an access easement as depicted on Exhibit A. The declarations, so this is paragraph A, 4A. Paragraph 4B describes the utilities, as does C. B describes the utilities easement for water, sewer, phone, gas, electricity, and other utilities over 5 feet in width, running parallel to the northern boundary. And C describes an easement for water, sewer, gas, electricity, running on the southerly boundary. So in other words, A describes the driveway that existed. B and C describe the northerly and southerly utility easements. Significantly, D, under the same paragraph, 4D, describes the duties with regard to landscaping on the easement areas. And D states the owner of the water, I cut it off because of the way I had to edit it into this, but it says the owner of the, I think it says upland parcel, shall have exclusive control over the landscaping of the easements described under subparagraphs 4A, B, and C. So again, shall have exclusive control over the landscaping, provided, so that means conditioned upon, that no owner of the upland parcel shall erect, construct, plant, or maintain any fence, rockery, shrubbery, or similar device for the purpose of denying access to the physically enclosing such an easement. So this is a writing. It's an agreement. That's what declarations are. They're agreements between property owners to be bound by the declarations. And here in paragraph 4D, it says, upland owner gets control of the landscaping, and they can do as they please so long as it's not done for the purpose of denying access or physically enclosing any such easement. So I want to table that paragraph for now, but I want you to have in mind that the intent matters and the actual availability of the easements matters. That said, the only utility easements described in the declarations and the short plat exist on the northern and southern boundary. You'll notice that none of these describes utility easements existing through the middle of the property, aka the garden area. Not described in the short plat, not described in the declarations. As now, Exhibit A to the 1981 declarations is a survey. And this, Mr. Ulbricht, unfortunately, is the root of all our problems in this case. And so I want to offer some explanations to you so that it makes sense. So the survey that's Exhibit A to the 1981 declarations was actually completed, and you can see it in the documents, but it was completed, I want to say, I think it was in April or May of 79. So it was actually done before it was done after the short plat, but before the declarations were recorded. And it was made an exhibit to the declarations. The problem and the confusion to the city and Miss Lynn and her council is that this Exhibit A describes the center line. Again, this is the one that's described in the declarations. And it says 12-foot easement for ingress, egress, and utilities. The problem is this last ampersand utilities that creates all the problems here. Now, this survey means that the surveyor who drew this wrote and utilities. What's critical is he also, or he or she, I don't know the gender, but also shows the utility easement on the south and the utility easement on the north. But unfortunately, the surveyor in 1979 wrote 12-foot easement for ingress, egress, and utilities. Now, to be clear, a survey doesn't create an easement. An easement is only created by a short plat or upon agreement by the parties. But the descriptions in these declarations, that is the paragraphs 4A, B, and C, are completely consistent with the survey except for the notation and utilities. So it's my firm belief, and I believe it's a fact, that this and utilities was essentially included by the surveyor because he or she didn't know, and it is not in any way determinative of there being a utilities easement in the middle of the property. Look through all the documents, all the title documents, everything you see. You won't find something creating a utility easement other than this notation by the surveyor who put it in the drawing. So, I mean, I obviously wrote the words in red and put the arrow. This is the only place utilities are indicated to be in the middle of the property. Other than this, I'll call it a Scrivener's error, there's nothing that creates it. And I don't believe the case law, the statutes, anything supports the notion that a utility easement is created by a surveyor's Scrivener's error. There has to be agreement by the parties, the landowners, and there has to be approval by the city in this case, which was done in the short plat. So I want you to understand what the confusion is from, and it's from this and utilities on the survey that was done in 1979. I want to point out that the survey corresponds, though, otherwise with the declarations, paragraph A, B, and C, because when you look at it, and again, this is unfortunately kind of a poor quality image, but A describes the driveway easement, and it says right here, easement number 1. B describes the northern easement, and when you look here, it says utility easement number 2, that's highlighted yellow, and C describes the utility easement to the south, and that's what it says down here, and it's not even legible on this copy, but it says easement number 3. Okay, yeah, it does says easement number 3. You can't read it. I have a better copy. But my point is that this was drawn, or these declarations were written up to correspond with the Exhibit A, which is the survey, and it does correspond in every way except for the notation of the and utilities that's put on the survey only, but not described in the declarations, nor is it described in the short plat. So fast forward, let's see, how 20, 30 years. Yeah, so we fast forward 30 years to 2011, and my clients have purchased the property. They've torn down the whole old house. They're building a new house, and they have to go through a very intensive, all-encompassing permitting process to do this, including moving the driveway. The old homeowners of parcel B were Dell and Patricia Keene. And my clients at the time said, okay, we got to move the driveway because we don't want it in the middle of what's now the garden area. We want it along the southern border. And so they drafted up this easement amendment with the Keenes, which is Exhibit 2006. It says, we hereby define, declare, and dedicate an easement for vehicular, pedestrian, and other ingress and egress and installation and maintenance of the utility, installation and maintenance of utilities over a portion of the above described property as described on Exhibit A and graphically represented in attached Exhibit B to Dell and Patricia Keene. So this amendment purported to move both the driveway and the utilities, but I don't believe it was it wasn't a concession that there was a utility easement. It was just saying, hey, we're moving the driveway and utilities. And it was really to check the boxes required for approval of their build. You need to understand that because they needed to have that moved, which subsequently wound up being at issue later in 2017. So this is Exhibit B to the amendment here. So this is what was attached. And so this is the graphic representation in 2011 that my client, Tammy, and her husband, Can, submitted to the city of Mercer Island and was approved. And it's a new drawing, and it legally describes the driveway as it exists presently. And it says here, access and utility easement, true point of beginning. And so it shows in 2011, under their plans, that the new driveway is going to exist where it presently is, and that utilities are going to be where they should be, which is under or adjacent to the roadway or driveway. Fast forward to 2017, 6 years later, and my clients had entered into another agreement with the subsequent property owner, but before Miss Lynn purchased. And sorry, I know this is submitted as our exhibits, but I can provide you the number. I meant to put it on here, but the city of Mercer Island at some point needed, they were unclear about the 2011 easement, so they needed to extinguish the old one and make it clear that where the driveway was. And so the legal documents say that there was this agreement entered into, I'm sorry, I think it was by Mr. Ma. Yeah. So it's between Can and Tammy and Mr. Ma. And they entered into a 27 agreement that was intended to extinguish the old ingress egress easement, and it did not affect utilities. And it states, whereas the location of the driveway through the Chu property is set forth in the May 17, 1983 RISE boundary line revision and recorded with King County. Whereas over the last several years, the driveway has been relocated and paved in its current location and is now being used by both parties. Whereas because the parties have slightly altered the location of the driveway as it approaches North Mercer Way, they desire this driveway relocation easement to cancel the previous location of the driveway and to adopt in its place the new location of the driveway easement. So 2017 agreement was all about the driveway, and it was really to iron out and make clear that it existed where it was with permission and with agreement of the parties. So now Miss Lynn filed this appeal, and this is a screenshot taken from her appeal documents, and this was she had done these red lines as part of her appeal to the city, and says she writes, utility easement lines are taken out in this version dated 9/11/2025, need to add back shown in 4/4/2023 version of survey. So Ms. Lynn, by virtue of her appeal, is asserting that there's an easement here, a utility easement line, and she's saying that, hey, she's essentially suggesting that Tammy and Can either surreptitiously or inadvertently, I don't know, removed the lines showing a utility easement. But that's just not true, because there never has been a utility easement in the middle of the property. Again, we know there's a water line, but it doesn't mean that there's a utility easement. So Mr. Yip and Ms. Lynn's statements, the middle easement, they're just saying rhetoric that doesn't actually make it so. The only thing that makes it so, if there's a utility easement in the middle, is the short plat. This is the document that dictates where the utility easement is. And that short plat document is essentially ratified by the language in the declarations that says, hey, there's a southerly utility easement and a northerly utility easement. There is nothing indicating a utility easement exists over the middle of the property. So the fact that there's an existing water line does not create an easement at that location. Again, this is a red herring. This drawing on the left of this slide is from the Locate company that came out last week, and they traced the location of the water line, which is fine. We know where it's at. We don't dispute where it's at. We're just saying that it exists in a location where, I'm sorry, I'm waiting for it to come back online. Did my screen go black from what you can see?
No?
Oh, shoot. Sorry, I'm having some kind of technical.
We did lose a video of you, Mr. Weiss.
Okay. Can you hear me?
Yeah, I can hear you.
Oh, weird. Give me a second, please. I don't know. I'm going to log off and back on because I'm having some kind of weird computer issue.
Okay.
Still?
Good to do that. I'll be right back myself.
My apologies. What the heck? Crap. Oh, really?
Okay, I can see you now.
Okay. Yeah, that was my apologies about that.
All right.
Okay. I think that my I exceeded my bandwidth
So you're
of
back on now? Everything?
correct. Yeah. So I was actually on my last slide. So
Yeah.
and I'll wrap up here shortly.
Okay.
So getting back to where I was. So the last slide shows where the water line locates. And the picture to the right is one of the photographs submitted by Ms. Lynn and her utility locate company. And we can see that the line runs under a approximately 2 foot tall, two paver or not paver stones, cinder block stones, but it doesn't interfere with it. Uh, we know from her prior declaration, that is Miss Lynn's prior declaration, that the pipes can be accessed, repaired, and managed, essentially using trenchless technology. And my client has allowed her on multiple occasions, twice within the last 2 months even, to come on and do whatever's needed to investigate and repair leaks, albeit apparently unsuccessful at repairing the leak and really only served to provide evidence for this hearing. Uh, in terms of your decision, Mr. Ulbricht, am I saying your name correctly?
Yeah.
Okay,
Yeah.
thank you. In terms of your decision, I don't think you need to decide whether there was an easement or not an easement. But my understanding of your scope of view and the obligation of you as the hearing examiner is to determine whether the city reasonably granted the permit based on what it knew and what it presently knows about the property. So the the city didn't know that there was an easement. And the reason that the city didn't know that there was an easement in that area is because there is not, in fact, an easement. Nothing supports the fact that, or nothing supports the notion that there's a utility easement other than the 1979 surveyor's notation of and utilities. That's literally the thing that supports the notion that there's an easement there. You won't find anything else that supports that. Now, it wasn't substantial error that the city committed in granting it. In fact, it was appropriate for the city to approve the garden permit. And let's take a step back and look at what this really is. It's it's a homeowner trying to stabilize their slope, trying to make a level area so that water doesn't run off and make it look nicer and be more functional. This wasn't done for some nefarious purpose. It certainly wasn't done to obstruct access to any utilities. And that's important to consider the declarations at play in this case. But the city didn't commit any error, so I think you can affirm their approval of the building permit and allow my client to finally move forward with their garden project to rectify anything that is out of compliance, including the pergola setback and so forth, so that she can complete her project. That's all my client really wants to do. And there's no actual harm, inconvenience, or anything caused to Miss Lynn by any of this. It stands to, frankly, protect her property better by having retention of dirt and soil and so forth upslope of her property. So there's no reason for her to object. My client has tried to do everything correctly. She obviously, my client and her husband obviously misunderstood the need for a permit initially. As their landscaper began the work and didn't have it, but they've taken every reasonable effort to hire qualified professionals to try and rectify that situation since that time. They're doing all this work in good faith with an earnest attempt to comply with the city's code. Nobody has said otherwise. A lot of the arguments that Ms. Lynn made here and her counsel made here are kind of beside the point. Like the different plans that were submitted in this case don't really matter. It wasn't on the notion of being deceitful or misrepresenting where an easement isn't. It's just that there has to be lots of revisions of plans in the course of building these things for compliance. It's that simple. It's not nefarious. Again, Ms. Lynn asserts there's a north easement, a south easement, and a middle easement. There is no middle easement. Once upon a time, there was a middle easement, but it was only for a driveway. I want to quickly address and dismiss the 2021 motion for summary judgment order that was brought before Judge Siegel. There was separate litigation about the location of the driveway in 2021 that eventually went before the court, and it was between these two parties. It's probably pretty obvious to you, but there's no love lost between these two parties, as unfortunately they've been involved in multiple lawsuits in addition to this administrative hearing. Judge Siegel's order did not say that there was a utility easement in the middle of a garden area. That's not what it says. It just says that his order doesn't make ruling on, and the reason his order didn't make ruling on it is because it was not at issue. So I'm going to pull that up here so that I don't have to necessarily talk about it in the abstract. So I'll do a screen share. Here, I'll make this larger. So, Mr. Ulbrichts, the only time that the notion of a utility easement comes up in the order is this, is right here, where Judge Siegel says, interpreting the 2017 agreement, the court does not conclude that it expressly intended to relocate the utility easements. So what Mr. Yip and Ms. Lynn want you to infer is that there was a utility easement in the middle of the garden, but that's not what the judge says. He's just saying, hey, it didn't intend to relocate a utility easement. It didn't address that. And I shared that 2017 agreement here, where it just describes the driveway easement. So I want you to just understand that the notion that there is res judicata or collateral estoppel as if this issue has already been adjudicated is completely false and misleading. Indeed, back in 2021, when this other litigation over the driveway took place, there was none of this landscaping in the first place. And in fact, at the start of that, Miss Lynn didn't even know where her water line was. So it's disingenuous to argue that, hey, this issue's already been addressed by the court when there wasn't landscaping done at the time. They didn't know where the water line was at the time. So this order does not mean what they're saying it means. It just, all it was, yep, the driveway easement was moved by agreement of the parties. And this is effectively dicta with the court saying, hey, it doesn't conclude. Unfortunately, it's got a lot of double negatives in there. But Judge Siegel said, interpreting the 2017 agreement, the court does not conclude that it expressly intended to relocate the utility easements. What you cannot infer from that statement is that there was a utility easement in the middle. That wasn't before Judge Siegel. If it was, I would have shown, or my colleague actually was litigating it, would have shown them, Judge Siegel, the short plat and the declarations, and even that survey that erroneously says "and utilities" in the middle, even though those aren't described in the verbal descriptions of the existing easement. So With that said, so I'm going to stop screen share. With that said, I'm asking that you find that the city correctly granted the permit, that you affirm the permit. Insofar as you're willing, I think you may make a finding that there is not a utility easement existing through the garden area, and that any utility easement exists only on the northern and southern boundaries. And I'm asking that you affirm the city's approval of the permit and allow my clients to finish landscaping their yard. Thank you for your time.
Okay. Yeah, just a quick question for you. The survey that first showed that middle easement, as the appellant calls it, what
Yes.
was what was that attached to again? What part of what document was
Sure thing. So it's in the record a couple different times. I so it is applicants. So it's Exhibit 2004 as submitted by applicant. Mercer Island also submitted it, I think, as Exhibit 45. And so what it is, Mr. Olbricht, is the survey was attached as Exhibit A to the declarations. So it's attached to the 1981 declarations as Exhibit A. Now, what's important is there was other boundary line adjustments, I think one in 81 and one in 83. And when they did those, they used the same survey to do the boundary line adjustments. And they never essentially put whiteout strip over the and utilities in the middle. And so that same survey was utilized a couple different times when there was minor amendments. And so it exists in the historical record of these properties in a couple different recorded documents, but it's the same easement that was, or I'm sorry, it's the same survey that was conducted, I want to say in like May of 79. So that's the problem is when your first survey has an error on it and then it's recorded multiple times on multiple documents, it's sort of people think that becomes the history of it. But everything else is consistent except for that notation of and utilities, but it does exist on the subsequent times that same survey is recorded with other boundary line adjustments.
So how was that when it was first put in the declaration? How was it incorporated by reference? I mean, did the reference say that that all the exhibits are as depicted in attached Exhibit A, or that's what I was kind of going towards there.
Fair question here. So I have it open here.
Okay.
So this is the declarations. And I just thought, so it says incorporation by reference. So you're on point with your question. It says, attached here to as Exhibit A are various legal descriptions of each of which refers to the property. Exhibit A and the descriptions contained thereon are incorporated herein by reference. So that Exhibit A, which is that survey, is incorporated by reference. But the ambiguity occurs because, so this is paragraph 1, 2, 3, and then when you get to paragraphs 4, these are the ones that I've highlighted in my slides to you.
Okay.
When you get to paragraph 4, paragraph 4A, 4B, and 4C, because of their verbal descriptions of the easement, are inconsistent with what is Exhibit A. Sorry, I'm scrolling down to that because it's affixed at the end.
Okay.
So the verbal, so it's incorporated by reference essentially in paragraph 1 of the declarations, but then the verbal descriptions describe only the driveway easement in the middle, utility easements to the south, utility easement to the north.
Okay.
But the declarations do not describe utilities in the middle.
Okay. Okay.
So,
Yeah.
so it creates an ambiguity, but my position is, and the case law and the RCWs and everything, I think support the notion that an easement has to be created by agreement of the parties, signed by the parties. And notably, the survey isn't signed by the property owners at the time. The declarations are, but not the survey itself. It's only signed by the surveyor.
But that those signed declarations incorporate by reference Exhibit A, but as you pointed out, that they're not legally described in the declaration, not the middle easement. So that's the problem. So what was the issue that was subject to resolution in the summary judgment ruling? I mean, what were the parties trying to accomplish there or disputing?
Well, I think it was extinguishing the prior. I'll say this. I didn't handle that, so I'm not in the best position to answer that question. My understanding is and I'd be happy to have Ms. Liu talk about it, but my understanding is the driveway, the city in 2017, the city approached my clients and said, although you have moved the driveway easement, you didn't actually extinguish the previous easement. And so I believe that there was the 2021 litigation was to extinguish the previous driveway easement. And my clients had believed they did so when they entered into the agreement in 2017 with the prior landowner, Mr. Ma, to move the driveway easement. So they were litigating whether the driveway easement through the middle had been terminated or not.
Okay.
And I may be incorrect on that. I'm not going to die on that or hill, because again, that wasn't my argument. It was actually my partner, Matt Kennedy, argued it. Miss Lynn's shaking her head, but I'll say the pleadings were submitted by the city, and so that they are in the record here. And that's
Yeah,
the
Morgan, you said it was not right. I'm sorry I have to cut in. So
Wait,
you
sorry.
speak for the other
Let him
lawyer.
finish. Sorry, Melina. I'm very sorry about that. You gotta let him finish. I can rebut him later. Sorry.
Okay.
Yeah.
Go ahead.
Yeah.
So, yeah, I'm not, Mr. Albrecht, like I said, I didn't handle it. The pleadings are in the record.
Yeah.
But what I think what's most important is the order just essentially it defers on the issue of the utility easements.
Okay. All right. Sounds good. All right. Thanks, Mr. Ways. All right. Now, Ms. Kiefer, and then after you, we'll take our little 15-minute break and let Mr. Yip finish it off.
Thank you, Mr. Examiner. I'm going to start with the easy parts of the case, which is the critical area review. There appears to be absolutely no dispute that the city appropriately issued a critical area 2 review. So that portion of this appeal, I think, can be handily dismissed. We have heard from testimony from the city's code compliance planner today that the building permit complies with the Mercer Island City Code as to the setbacks. So the structures right now, they don't necessarily meet Mercer Island City Code. As approved on the plans, they will. This will be verified by inspection prior to finalization of the building permit. So the issue as to compliance with the setbacks, that can also be dismissed. And so finally, to the bigger question, the easement issue, the record has shown, if nothing else, a tortured property rights history as between these two parcels. Frankly, the city struggled with the property record as it stands because it is, like I said, long and tortured. And the city's interest in this proceeding is simply to have a clean permit decision. So really the question is whether the examiner sees that the property rights issue, whether he agrees with the applicant or with the appellant. So if the hearing examiner agrees with the appellant that the middle easement exists and doesn't permit encroachment, then the appropriate remedy is to remand the decision for the applicant to revise their building permit application to move the retaining wall out of the easement area. However, if the hearing examiner agrees with the applicant, then the correct decision for the examiner is to uphold the city's permitting decisions in its entirety and dismiss this appeal in its entirety. And that concludes our closing statement. Thank you.
Okay. All right. A little briefer than the last one. Yeah,
Yes.
So. Okay. Well, let's take a little break until 2:40 for Mr. Yip to do his final. Then we'll see you then. Appeals, February 27th, 2026, 2:40 p.m. At this point, we are at the final closing argument from Mr. Yip. So go ahead, Mr. Yip.
Thank you, Mr. Hearing Examiner, and just thank you. I want to thank everybody for being here today. And now I will give a brief presentation as well, but I'll try to keep it short. I will start from the decision that we are appealing because the language of the decision is very important. The decision primarily addresses critical areas, which, as the city correctly notes, we are not appealing. However, what it does say with regards to the issues that we are appealing is as follows. It says the new retaining wall is proposed to be located outside of any easement area, as the previous easement for ingress, egress, and utility has been relocated to follow the existing driveway, recording number 2017 0329 001022. And just for the hearing examiner's reference, this is page 192 from the city's exhibits. So right off the bat, there are at least two facial mistakes on this particular decision. The first, as the city has helpfully described, is that this decision was not based on the 2021 order. Did not even address the 2021 order, and the reason for that is because at the time this decision was made, the applicant has not provided the 2021 order or provided it. And this is so even though the applicant in her testimony indicated that she was aware that there was such an order. So on its face, this decision is at the very least incomplete. But moreover, this order is directly contrary to the previous order issued by Judge Siegel of the King County Superior Court by finding that the previous easement for ingress, egress, and utility has been relocated to follow the existing driveway. Now I shall move to the city's exhibit number 44, which is the order, and I circle the area at issue. And I will get to these recording numbers shortly, but it says that there's three documents. It says inclusive 12-foot easement for ingress, egress, and utilities, easement number one.
I'm sorry to interrupt. Is Mr. Yip presenting something?
Yeah, Mr. Yip. Are you sharing your screen or trying to? You're not getting it.
My apologies.
There you go.
Thank you. Okay, so originally I was talking about the document 192, and I also talk about this. So now I'm talking about the order here.
Right.
Okay, and the order says there's these three documents, and that they include a 12-foot easement for ingress, egress, and utilities, easement number one, which remains in effect and as a matter of law was not modified or terminated by the party's private 2017 driveway relocation easement, and it mentions the recording number. And this is directly contrary to what is in the city's decision, which says that that easement was relocated to follow the existing driveway. And the order controls because it is already issued by the judge and it has already been confirmed by the parties. And we know this because the parties after this order was entered on November 5th, 2021, the parties stipulate that all claims in this action have been fully and finally resolved by orders of the court. So this is a final order. It has not been appealed, and there's no pending appeal. And being that it's a 2021 order and the 30-day period for appeal has long passed, this cannot be appealed. So on its face, the decision is incorrect, based on an incorrect premise, and it should be reversed. I also just want to talk about the background for the order. The applicants would say that the order only addresses whether the driveway has been relocated. Actually, this is incorrect because if you look at exhibit number 42, which is the actual motion for summary judgment, it presents the following issues. Number one, does Ms. Lin have utility easement rights in the area shown on the 1979 plat amendment and the 1983 plat amendment? That's the first question. Second question, did this 2017 driveway relocation agreement terminate the utility easements shown on the 1979 plat amendment and the 1983 plat amendment? So from the motion, on the face of the motion for summary judgment, it is directly targeted whether or not she has utility rights. This is already fully litigated in the prior action, culminating in the 2021 order. And these are not mysteries that need to be resolved now, and they are resolved previously. And we also note that under the legal doctrine of res judicata, as established in various cases, such as Oakster versus WSBA 198, Winnapt and 758, and from a 2017 case, and also other cases like it, it applies to not only issues that were litigated, but also issues that could have been litigated. So while we appreciate the applicant taking the time to comb through all the documents to see, like what they say and what not say, ultimately, if all those factual issues have already been resolved in this motion for summary judgment, which was granted in its entirety, this motion. And so those issues are not outstanding. If the applicant believes that the order was in error, then the applicant's recourse would be to appeal it at the time. But again, the applicant did not appeal the order. And so therefore, the order is final on these issues. So does Ms. Lin have utility easement rights in the areas shown on the 1979 plat amendment and the 1983 plat amendment? Yeah. And was it relocated by the 2017 document? No. And we also see this again, it says that it remains in effect, this easement for ingress, egress, and utilities, and as a matter of law was not modified or terminated by the party's private 2017 driveway relocation easement. Just also want to just briefly touch upon the underlying documents because there were three that are mentioned, which I'll call this 1978 document, the 1979 document, and the 1983 document. These documents, the contents are not really disputed, and I understand the applicant's already gone through them. I just will briefly touch upon them. The 1978 document shows a drive and utility easement that curves in towards the south of the property. But when you look at the 1979, they amended the easement, and it says revised location. So it's expressly a revision. It says revised location of 12-foot easement for ingress, egress, and utilities. And this document is the Exhibit 43 from the city, page number 335. And this is exactly what we're calling the middle easement. The middle easement is established by the 78 document, the 79 document, and the 83 document that I'm about to talk about, and also confirmed by the 21 order. It's not the middle easement is not established by conjecture, nor is it established by mere speculation, but rather by documents that are long recorded. So moving on to the 1983 document, that 1983 document was apparently signed by the respective, what appears to be the respective owners of the properties. And also it seems to have been approved by Mercer Island. There seems to be a stamp here. And this is from, this is again for your references, document 337, page 337 from the city's exhibits. And this one is the final, probably the final word on the easement at issue. And it also shows that easement running down the middle of the property. Now, one thing that I would like to clarify, which is a bit unfortunate, but I understand has created quite a bit of confusion, is that there is that 1981 declaration. And that 1981 declaration did create a driveway easement in the same, apparently in the same location. And that is, I understand that is unfortunate and somewhat confusing. but that was a separate document, the 1981 declaration. I would note that the court's order did not rely on the 1981 declaration, but rather just on these three documents that we just talked about, these short plats, these survey drawings. So because of that, the 1981 declaration, quite frankly, is irrelevant as to the middle easement. And so because of that, the terminology, the phrasing in that one, allowing some landscaping, it's not applicable here. And in any case, it also mentions that retaining walls, generally for enclosing property, needs our consent anyway. But again, I don't want to distract from the main point, which is that those terms are about the north and south easement, not the middle easement. The middle easement was not from that document. So because the middle easement is well established, the question then is whether there are structures constructed there. And for that, I would like to turn to the city code. This is Mercer Island City Code 1920-020H. And it says here, part 2, no structure shall be constructed on or over any easement for water. And it also goes on to mention utilities, but even this water is the key to what we're talking about here. And this is a pretty absolute provision. It does not require that the easement be in use. It does not require that the easement be fully used. And it also does not require a showing of actual interference. It just says that if there is an easement, then you cannot build structures on top of it. And the definition of structure in the Mercer Island City Code 19.16.010 is also very broad to mean that which is built or constructed, an edifice or building of any kind, or any piece of work artificially built up or composed of parts joined together in some definite manner. Moreover, the issue of a retaining wall has already previously been determined by the city to be a structure, and we know this from the Lynn Exhibit 1001, which was for the 2011-2012 construction of the applicant's house. And at that point, the city told them that they cannot put any retaining walls in that they cannot put any retaining walls in the I think at the point it was in the setback area, and also on the easements in the side yards. So the fact that retaining walls are structures, this is also established, and the definition of structure is very broad. So really, coming back to this ordinance, there's really only two elements that needs to be shown. One, is there an easement? And as we just discussed, there is indeed a middle easement. It's established by those three documents confirmed by the court. That's res judicata, and it cannot be relitigated. The time for appeal has also passed. So the question then is the structure being constructed on that easement? And the answer also is yes. Because if you look at City Exhibit number 9, you will see that this drawing, it shows this easement here, and we see that there are at least several parts here of hardscaping that are on this easement. And the city, from what I understand, if I understand the testimony correctly, is that if in fact there is a hardscaping, these structures on the easement, they have to be abated. In the more recent the approved plans, the applicant, for reasons unknown, just omitted the easement. However, they did not alter the structure at all. The structure remains in that location, and we know that to be the location of the easement. And finally, with regards to that, we also have the recent photographs to show, yes, in fact, in the waterline area, there are these types of retaining walls. This, again, the point of this photograph is not to show, actual interference or even the degree of actual interference, because that's not a required showing under the ordinance. But it's to show that, yes, this retaining wall actually does exist, and it does exist on the easement area. And because of that, it is an actual structure on an easement that needs to be abated. And because in sum, what we request is that the hearing examiner reverse the decision and remand it back to the city to require the full abatement of any structures on the middle easement. I also understand that there was an issue with the north easement, but this site plan, the approved site plan 23, already removed the calls for the removal of those encroachments, which is great, and we appreciate the city's help on that in requiring that revision. But again, the middle easement revision retaining walls that remain in that location, they also need to be removed. And finally, with regards to the setback, I understand that the city will require the applicant to follow this approved site plan and will do such surveys or inspections, require such permits, maybe demolition permits or the like, to make sure that this work is done correctly. If there's anything more to be said about that point, it's just that the decision didn't really address the setback. So if some provisions can be included, that might be okay. But otherwise, we trust the city to enforce that code. So in sum, again, the main point is that we request that the retaining wall and any structures be removed from the middle easement, which is established by the 2021 order. Thank you.
Okay, thank you, Mr. Yip. All right, I think yeah, I think all council has covered everything really well. So the major issue I think for me in review of this is whether the summary judgment order recognize that middle utility easement or not. That seems to be how the applicant is their position that summary judgment ruling doesn't apply. So that's what I got to figure out there. The fact that it does mention that 12-foot easement seems to be something that is weighs pretty heavily in favor of the appellants there. So that's going to be the major issue I look at. I mean, I think if the summary judgment order does cover this and does essentially require that we recognize that middle easement, I think that the appellants will likely prevail. I mean, there's the issue about how to apply the code, about whether the structures are intended or had the purpose of preventing, I think it was vehicular access or something, but beyond that, it's the summary judgment ruling that's going to be key. So that's what I'll be looking at real close. I don't know off the top of my head where we're headed on this one yet, but like I said, those are the major issues I'll be looking at. So I think we covered.
Mr. Oberg, can I be heard on something just very briefly?
Okay, all right, go ahead.
I appreciate it. I didn't handle that previous case. I talked to my client about it in the little break we had. And I guess I would ask that I be able to supplement with, insofar as the prior litigation is determinative or important for decision making, that I'd be able to provide you with briefing and other pleadings in that case. Because I want you to be aware that the complaint in that case was filed by my clients against Miss Lynn, and it had to do with waterfront access to the water. Was the main issue in that case. And my clients prevailed and eventually got like a $42,000 judgment for attorney's fees against Miss Lynn on it. And so the primary issue in that litigation was my client's ability to use Miss Lynn's driveway to access Lake Washington. It was not the driveway up on my client's property. So plaintiffs or Ms. Lynn or counsel are trying to pull the wool over your eyes on that. And I don't think that's intentional. I don't think Mr. Yip, in fairness to him, was involved in that, but it's not what it seems. There was multiple summary judgment orders because in May of that year, Judge Spector granted my client's motion for summary judgment on a separate issue. So they're trying to pick and choose bits and pieces and just piecemeal them to you because there is one order that has one ambiguous piece of information, and they're trying to make it rule here. So you really don't have the full picture here.
Okay.
I want you to understand that. And I'm happy to provide the full picture, but frankly, I didn't know that that's what this case was going to be about. Because Judge, oh, sorry, who was it? Judge, not Lappin, who issued that order. He didn't have the full picture either because he was just ruling on a narrow, discrete issue, which didn't include the placement of the utility easement.
Mm-hmm. But how do you? But he did. I mean, in the order that the portion that was identified by Mr. Yip, he did expressly identify that 12-foot easement there. So it looks like he did understand that to be the utility easement that wasn't being displaced.
Well, it presupposes it exists in the first place. That's the problem, is that there was a presumption that it existed in the first place. He didn't go into this analysis of what I've explained to you and argued already, which is hey, the deed and the declarations create the easement. That really wasn't before Judge Siegel in 2021.
Okay.
It I know that sounds strange, but this is a long, convoluted
No,
history.
I get it. Okay. Well, yeah. Okay. I'll allow it. Of course, Mr. Yip will have an opportunity to respond. I mean, give you a week to provide that. Is that enough time?
Yeah, and I could provide it by the end of the day. I don't intend to make any argument or anything. If you're going to look at the pleadings in that case, I think just looking at one or two pleadings in a vacuum is
Okay.
a disservice.
All right. Yeah. Yeah.
May I
Sure.
say a few words?
Yeah.
Okay, that's a few comments. First, these documents were provided by the city as the city's exhibits, and this was provided a couple of weeks ago. So everybody already has the time to provide any additional documents that may be necessary to provide the full, quote unquote, the full picture. And since they have not provided anything to provide now is untimely. That's the first thing. Number two, to the extent that they can provide any additional documents, and we're not agreeing to providing any, we do not think that they should be allowed to provide additional argument. If these are what they're trying to provide are documents that already exist in the docket, that may be a different issue. That's a matter of public record, and I believe that maybe you could even take judicial notice of whatever it is in the public record. But we would not agree, and we do not think it's fair for them to try to provide supplemental briefing to essentially re-argue the 2021 motion for summary judgment.
That's not my intention, just to be clear. I'm just talking about just providing pleadings so that you have a more comprehensive picture. So because I understand and respect what Mr. Yip is saying. I don't intend to argue anything more. I just think context is necessary.
Well, I guess it's Mr. Yip, you're saying the city gave that a week ago, but I mean, that was when all the exhibit lists were due, correct? And so the applicants weren't aware that the summary judgment ruling was going to play a central role until the exhibit lists and pre-hearing briefs were submitted a week ago. Isn't that correct?
Not no. So what happens is the city actually provides their materials 2 weeks ago, I believe on the 13th, and we provided us 1 week ago. So if they think that they need more documents, they could have provided it. They would have known that the order was in there.
Sorry, yeah. Dealing with 36 jurisdictions, and most of them, everything's done at the same time. So, okay, no, I'll stick to the record that I have then, I guess. Yeah, that's a problem. So we'll just leave it at that. And like I said, I mean, it looks like there's enough information to make some conclusions there. So that's what I'll do. So anyway, but yeah, I think everything, has been covered really well. It's given me a lot to work on here, and I got about a couple weeks to issue that decision. So we'll stick to that schedule. Thanks everybody for participating today, and we're adjourned. So have a great weekend.
Okay, thank you for your time.
Thank you.
Thank you.
Okay, thank you very much.
Thank you, Judge and everybody.